submission. It was listed in November 2022. If
Go before
possible,
court number 5.
Item 13, I would like to withdraw this.
21 meter, 19 meter, my lord.
I can't help it.
Okay.
This is not the court which is going to grant any permission out there. This court doesn't have the authority to do
But,
that.
I heard that
All
as per the
mention,
year,
you see, all mentions for listing of cases for any urgent matter must be made at 10:30 PM before the respective benches. Bench court I'm taking bench 5. So court number 5 is the main court.
Item
Next.
13, Lord. I would like to withdraw this.
Item number 13.
Yes,
Okay, Mr.
sir.
Azad Ahmed, the learned counsel for the petitioner, submits that he has instructions to withdraw the instant writ petition, for which the instant writ petition stands closed on withdrawal.
I beg to mention item number 39, my lord, the contempt matter. All the officers has changed, my lord. Therefore, I want to implement new incumbent. My lord, kindly allow me 6 weeks time.
Mr. So-and-so, huh?
Thank you.
Mr. M. Saikia, the learned counsel appearing on behalf of the petitioner, submits that there are new incumbents who have joined the post, wherein the petitioner is seeking compliance to the order passed by this court. He submits that he would require appropriate for some accommodation for taking steps against the new incumbents. List the matter after 6
may I
months.
please go?
With the consent of others, I beg to mention answer item number 5.
Item number?
5, lord. Okay. Letter may come after 2 weeks, lord.
Why?
Politic counsel A. Sharma is out of state.
Who?
A. Sharma.
Item number 5.
I am put a respondent 1 to 4.
Matter pertains to
Blacklisting. lord.
Blacklisting.
blacklisting. We give a stay to them. They know very well. No problem. What do you say? No adjournment.
And number 1 and 2, permission.
Rajiv, the 9.
Yes.
Quite old matter, my lord.
2012.
Yes, my old matter.
Yes.
What
Yes,
happened,
what
my
is
lord?
this matter about?
This is about eviction of the petitioners. There are 15 petitioners, my lord.
Eviction.
Yes. They're
Eviction
staying
from?
in Kalapahad area, my lord.
Huh?
In Kalapahad area,
Ah,
they're staying, they constructed houses from in 1975 to 85, my lord, in between.
ah.
Now, they came for eviction of the petitioners. In 2007, my lord, we approved this honorable court. Page number 23, my lord, the order passed by the honorable court. The chief secretary was directed to constitute a committee and to submit a report and to resolve the issue. My lord, page 23, order dated 15/6/07, my lord. Kindly have a look at that. Page 23, annexure 2.
Yes, all the
Operative part, my lord. Operative part, page 25, my lord. Paragraph 6, my lord.
Huh?
Paragraph 6, page 25.
Yeah.
Operative part. In view of the above, the writ petitions are disposed of with a direction to the respondents, particularly the chief secretary to the government of Assam, to constitute an appropriate committee consisting of officers from concerned departments, including the forest and revenue department, look into the matter and to suggest to the government actions to be taken to resolve the dispute, my lord. This is what. And next page, my lord, last page, page 27. Meanwhile, status quo as on today shall be maintained, my lord. My lord. Thereafter, 19412, my lord, worship fills the order. In the order sheet, worship will find an order dated 9412, my lord. Of this case, 9412. By Honorable Justice Rishikesh Roy, my lord, that what are the before
Yes.
signature response? That's good. 9412. Last paragraph, Lord.
So,
So ultimately, they
the
can
status quo which was given
yes,
by the order dated 15/6/2007
7
was limited.
limited. Thereafter, my lord, what happened? They constituted the committee in 2009, my lord. Kindly come to page number 37. That order was completed in 2009. Kindly come to page number 37.
30?
37 page number, annexure 6.
Okay. Then
Yes.
Then what happened?
Yes, then my lord, they constituted a committee and they made two reports. Chief Secretary was directed to submit affidavit. Chief Secretary submitted two affidavits, my lord. In this case, in the affidavit, I'm just bringing it to notice. He will find in the inquiry report, contents are different. Same report, contents are different, dates are different, my lord. Something very peculiar, my lord. Lordship, I'll show to your lordship, my lord. That was taken note of your lordships, my lord. In the order dated, my lord, 5/6/23, my lord. Last order, my lord. Last, second last order,
I
third last order.
take
5/6/23. This is something very strange, my lord. How come same? Second paragraph.
Yes, then
Now, my lord, please come to the affidavit filed on 26/2/18. I'll show two this reports, my lord. Something strange, lordship will find, my lord. A chief secretary has filed this affidavit, my lord. That's why this order was passed. to
Mr.
me.
Nath, let us make the matter simple.
Yes,
There is a direction by this court by then order dated 15/6/2007
yes,
to constitute a committee consisting of officers of the concerned department, including forest and revenue, and to look into the matter and suggest to the government the actions to be taken to resolve the dispute.
my lord.
So it starts from there.
Okay, yes.
Whatever they have done is done. Now let us hear them. Yes. Chief Secretary, who is appearing? You are appearing.
I'm not chief secretary, I'm appearing for the revenue, but since here, my lord. The
No. Who is appearing for the chief secretary? The chief secretary is a party?
Chief
Chief
secretary.
secretary is a party, but
Fantastic.
the latest affidavit,
So there is no representation of the chief secretary?
I am appearing, my lord.
You are appearing?
I am appearing in this case because on,
No. What is your authority to appear for the chief secretary?
because I have filed the affidavit on behalf of the chief secretary.
You have filed a wakalatnama.
No, Wakalatnama is there.
Are you the standing counsel of the chief secretary?
No,
Are you the standing, you are only the standing counsel of the revenue department?
revenue department, but here, my lord, since order was passed by this honorable court, pursuant to order, my lord, passed by this honorable court, and affidavit has been filed. Two affidavits had been filed.
Understood. The affidavit has been filed. You have only brought it out here.
Yes.
That's a different thing. But do you have the wakalatnama for the chief secretary?
No.
Then what is your authority to appear?
No,
You have not been appointed by the office of the chief secretary to represent the chief secretary. Is it?
That is one way of looking into the.
That is the only way of looking into it. Because tomorrow, now if I pass an order, you may tomorrow say that I have no authority to appear for the chief secretary.
So it is on record since I have filed an affidavit on behalf of the.
Affidavit filing is a different thing.
Yes.
You are just putting it out there. That, are you saying that any person out there who files an affidavit without a wakalatnama, unless specifically entrusted, would have the authority to do so?
I may not comment on it.
Tomorrow, Mr. S. Burua, out here, he files an affidavit on behalf of the revenue department. And can this court make the revenue department accountable on account of the submissions made by Mr. S. Burua if he is not being entrusted out there? No,
Convention says so, because.
convention is different.
Yes.
Where is the convention? The convention has to be based on some rules. Then, where is it?
Lordship is correct, but here sometimes it so happen, my lord.
Okay, anyways,
my lord.
tell me, what is the chief secretary? Why the chief secretary has given two reports?
Yeah, my lord, I have sought for the instructions, but that instructions is not forthcoming.
Okay, that is why you are nobody. That is why I'm saying there's an instruction being sought for in the month of June and the chief secretary has not given. Then what is wrong? And there's a simple direction to
Right.
constitute a committee and take a decision. Why haven't you not? Why there are two reports?
No, Lordship will kindly see it.
Because here is a very serious thing. If the chief secretary on affidavit has filed two reports,
Yes.
which as per the order passed by this court is different,
My lord,
both are different,
Yes.
then in that case, there's some hanky-panky done by the chief secretary.
So, my lord, Lordship here will kindly consider the contents are similar. Only the signature is down below.
Absolutely.
Yeah.
Why there are two things which have been enclosed by him of the same date? Same date.
And,
Hasn't he done something very serious thing?
One contains 4 paragraphs, another contains 5 paragraphs. Man, how-
Then it's a very serious thing. That is why I asked you, what is your authority to represent the chief secretary?
Because this affidavit was filed, my lord, on basis
Get
of-
your instructions, 2 o'clock. Whatever may be. Why there are 2 affidavits filed? This can't happen in this man.
Item number 3,
Yes.
Yes, may I please your lordship, here from respondent number 3, affidavit is awaited, and my reply to affidavit in opposition filed by respondent number 2 also is there, lordship. I will file my rejoinder.
Have you filed a reply?
No, lordship, I'll file, I need some time because she could not come down here to sign the document.
How much time?
2 weeks, lordship.
Have it after the October vacation. This court had by an order dated 2/8/2023 at the request of the petitioner granted time till today for filing the affidavit in reply. However, no affidavit in reply has been filed on the ground that the petitioner could not make time for filing the affidavit in reply. In that view of the matter, list the matter on 15th of November 2023.
Meanwhile, lordship, the social welfare department may file their reply so that.
Not
I-
necessary, you are not interested in filing, why should we? Why should I
Lordship, there
direct
was one
anything?
scheme-
No, madam,
Because the
nothing.
order was there on the
You
last-
cannot ask for all these things. First, when you have not complied with the order of filing the affidavit.
item number 4,
My lord, do we have filed the affidavit?
Hmm.
Whether it has come up, report
Affidavit
by respondent number 7, my lord.
oh, not some.
It was filed on 21st.
Oh, that is very relevant. Whether he is going to pay. Respondent number 7 is willing to pay.
No, my lord. Yes, there was some miscommunication, my lord.
Oh.
We have filed an affidavit, we have explained the position, my lord.
Oh.
Lordship will have to adjudicate the matter, my lord.
When, okay.
It
you
was
have
filed on
filed-
21st. my lord.
The Mr. Kane Chaudhary, the learned senior counsel submits the respondent number 7 has filed the affidavit as directed by the court by the order dated 7/8/2023. However, the said affidavit is not on record. List the matter again on 13th of September. The registry shall enclose the affidavit filed by respondent number 7. The petitioner is given the liberty to file reply if
Yeah.
so. If-
I have filed affidavit for respondent number 2. That is on that.
Thank you. Thank you. If
5,
May I please, Your Lordship? Lordship, this case is regarding the blacklisting. They have challenged the blacklisting order, Lordship, pursuant to issuance of the so-called notice regarding involved of the allegations of adulteration regarding NAFTA, Lordship. The said blacklisting order is page 45, Lordship. The blacklisting order was.
Where is the petitioner?
I think the matter has become infructuous because Lordship may. peruse
Then
the
why
page-
did you want for an adjournment?
Lordship, I have not gone for a report.
Huh?
Lordship, I have
Who is
not-
the petitioner counsel?
Yes.
Elbert Thakur. He was here somewhere. I saw him when the matter was taken up. We would like to inform you that during the transit, your so and so was involved in mental protection of the chamber and so and so. The fee of that so and so has been taken for 2 years. For 2 years is complete,
Yes, sir.
so nothing remains. Okay, let Mr. Bhattakur come. Yes, Mr. Bhattakur. This matter has become infructuous.
Because your lordship, with the blacklisting, your lordship, there are penalties also there, your
Where is the penalty?
lordship.
You have challenged which order?
Lordship, allow me to bring back 5 your lordship.
Page 28, Lordship.
Blacklisting.
You have only challenged this 3/7/2019 order.
Lordship, as a result of this, your lordship, my security deposits, my your lordship, bank guarantees, everything has been your lordship.
There is nothing not mentioned.
Not
Is it
mentioned,
mentioned?
but that is what is happening, your,
No, it is there, but is it mentioned anywhere? No.
we are not getting it back, your lordship.
That you can very well do it.
And it is related to blacklisting, your lordship. And blacklisting itself is bad, your lordship. On the ground of violation of the principles of natural justice, your lordship. Before issuing this order, your lordship, they have not issued any notice to me, any
No, Lordship.
chance or
Page
opportunity. or
39 is the.
I will
SOCOS
show it, your lordship.
Page
from my
39 is the SOCOS
record.
notice, and accordingly, in presence of 39, Lord.
So cause no. Is
Yes.
given.
He was replied, and accordingly, he was several times asked to present.
You are
in pre-
hereby required to show cause in writing within 15 days from the date hereof as to why you have not placed on the holiday list and depart from entering into any contract with Indian Oil or be then delisted from the list of so and so for the following reason. Enter remand which was dispatched from the Guwahati refinery on so and so. During routine checking of so and so, high quantity of water was observed on the top platform box. Was detained and subsequently checked in presence of the driver on the next date on so and so. Water was checked with a deep throat and found the rear chamber that contained the chamber one. And your reply, if any, to be supported by the all documents and documentary evidence which you wish to rely upon.
And
If you fail
pursuant-
to do so, reply to the show cause. Yeah,
Lordship, let me,
and Lordship,
there is a so-called, I replied. Thereafter, there is an inquiry. There is a detailed inquiry report, your lordship. Only on the basis of the recommendation of this detailed inquiry report, your lordship, they have blacklisted me, your lordship. These documents, copies of these documents, your lordship, this report has never been supplied to me.
where is it mentioned in the order of 3/7?
Your lordship will kindly see in their affidavit, they have said so, your lordship, that there is a detailed inquiry report. They have annexed that detailed inquiry report, your lordship, in their affidavit.
Hmm.
And in the only after your lordship recommendations made by that inquiry, your lordship, if your lordship go through their affidavit in opposition,
As a
your lordship
slip
will
of
get it,
paper,
your lordship.
I have the honor to say.
Page
to
64,
cite
your lordship, of their
the
affidavit in
inquiry.
opposition. Page 68 is the detailed inquiry report.
Let us see the inquiry report.
Your lordship will
Lordship,
kindly come to page 68.
Page,
first,
68.
Lordship, may first page 65.
wait. You look in, yes,
65 is the first
Page?
inquiry. 68 of the affidavit in opposition.
68. Yes,
Your lordship will kindly come to page 76, conclusions and recommendations. As per the lab report, it is established that material inside chamber number 2 and 3 of TTL are adulterated. As per clause number oil industry transport discipline guideline version 4, if the product passes the lab test, the TT shall be decanted at the consignment premise. If the product falls in the lab test, the TT shall be sent for the disposal of the product as directed by oil company. Since clear case of adulteration, committee recommends for decanting, deposing the material suitability as such a clear case of malpractice is established with intent and purview of in the oil industry transport discipline guideline purposes. So established case of field forest non-delivery of product is established. Then recommendation. Based on the observations above, IRCTC norms following recommendation are made by the committee. During the validity as per ITDC clause 8.2.28, TT shall be blacklisted.
That was done, Lordship, in presence of the driver of the.
Yes, now tell me. You see, you were issued a show cause.
Lordship,
Your show cause was issued on 11/5,
Lordship,
saying that there are certain compartments where there is some water.
Lordship.
You have replied to that. And pursuant to that, an inquiry was held. Now that inquiry, that particular truck was asked to be brought in, which was brought by you.
Lord.
And you had authorized your driver to be present, which you can see at paragraph
Page-
4.4,
Page 65, your
page 72,
Lordship.
page 72. What additional natural justice is required?
Lordship, after this, your Lordship, after this inquiry conducted, your Lordship will kindly come to the page 68. This is a detailed inquiry
Page?
conducted, page 68. This is not part of this, your Lordship. This is a detailed inquiry conducted by 3-member, your Lordship.
Yes. So
After this.
you
your
have
Lordship,
been, what is the inquiry being conducted? You have been asked, so cause that kindly tell me. You say that because of Operation Cyclone Funny, this has happened.
Lord.
That is your thing.
Okay.
So they asked you to bring the truck. And when the truck was looked into in presence of your representative, it was found that, and this is the inquiry report, then
No, your Lordship will kindly see the page 68 onwards, your Lordship. This is the report, your Lordship, detailed report, your Lordship, which is not there in page 65 to 67. And in this report, your Lordship, 72, your Lordship, none of my representative has signed, your Lordship.
where?
This page 68 report, your Lordship.
Not necessary for you to sign. You have been asked to grant the tanker, that's all.
I brought it, your Lordship. They found something, your Lordship. Am I not entitled to give a reply to them, your Lordship? Before your Lordship blacklisting, they have taken a steps, your Lordship, by which there is an adverse civil consequence.
No, you say that it was because of Operation Funny, the cyclone, this has happened.
Lordship.
But they have looked into it.
Now, if
Now,
your-
can this court now, thereafter, where is the question of any further
no,
natural
your
justice?
Lordship is not required to go into the merit of the case. But your Lordship, I have a right, your Lordship, to object to what the finding of the inquiry committee, your Lordship, because a driver has signed on behalf of me, your Lordship. A driver has signed, your Lordship.
You
But-
have authorized the driver.
I have authorized not to submit objection, your Lordship. Just he was there in presence, they have found something, then there is a.
You were asked to produce, kindly read page
Lordship.
4.4. Page 72.
One point, the TT Career Enterprises Guwahati was asked to report to Rigbo Refinery for joint physical verification, your Lordship, of the
Listen,
TTL. In course of communication, the transporter expressed his inability to trace the original driver of TTL. And further to this, the transporter authorized another driver, Jagannath Mess, to represent in a joint sampling and physical verification exercise, your Lordship. Now your
then
lordship,
read it.
kind-
Whatever.
But
you-
he did not turn up. Considering this, Pritam Sahni was authorized by the transporter and he reported to Digboi refinery on so and so for the purpose of joint sampling and physical review. Now your lordship will kindly. see-
Then. Read it further.
After arrival of the representative of the transport, the exercise was taken up by presence of the committee members, co-operative in charge, shift operator, lab sampler, transporter representative and CIF personnel on 22/5/2019, and the exercise continued on 23/5/2019. A report on the physical checking and prepared 25/5/2019 and signed by the representative of concerned departments along with the transporter representative, CIF representative attached annexure X. Since the vehicle could not be started due to discharge of battery on 22/5/2019, the exercise continued on 23/5/2019. Following of the details of the exercise. This is the exercise, your lordship. Then your lordship, what they have observed. External water accumulated at the top of chamber box was drained. Then they have waited. This was what they have said, your lordship. And then conclusion and the recommendation. Now your lordship will kindly see the page 66. 7 persons were present, your lord, in 66. This is the physical checking, your lordship, where sample was collected, your lordship. After sample was collected, it was sent, your lordship. Now your lordship will kindly come to page 67, last page, last line, your lordship. After sampling was collected, page 67 for a moment, your lordship.
Yes.
Last line. After sampling was
No,
done.
no, after the 7th August.
Yeah.
7th August, what has happened? Have you taken any action pursuant to that? Kindly see at page 129, running page 129. Annexure R10. Have you taken any action on the basis thereof?
Hereafter, this honorable court has passed a no coercive action note in a IA filed by the petitioner.
Okay.
There is an order for no court.
Mr. Bottako, this court is not.
Lordship will your lordship
Nothing
pass
doing.
order, your lordship as per your lordship, feels your lordship.
I
But my case is this, your lordship. Your lordship will kindly hear me for a moment, your lordship. Page 67, your lordship will kindly come, your lordship.
Of?
Of the affidavit in opposition.
Yes.
Last line, your lordship, it can clearly seen that test results of Guwahati refinery and Digboi refinery are not matching. And detailed analysis and report will be submitted by the committee shortly.
Hmm.
Now your lordship will kindly come to page 68. These are the 3 members of the committee, your lordship.
Hmm.
It is not that my representative was there, your lordship. If committee constituted of 3 members, they, your lordship, made detailed analysis. Test reports were your lordship seen, your
You
lordship.
were very much present.
No, in this, I am not present, page 68, your lordship.
Enough, Mr. Dey.
This is,
Heard me.
no, lordship may kindly
The instant
record my
repetition.
submission. Your
No, no,
lordship.
no, no,
I
no.
am relying on certain judgments, your lordship, that also your lordship.
Okay, you give it.
Lordship. This is 1989, 229, your lordship.
Give it to me.
Small judgment. Para 4.
Yes.
Para 4. Indisputably, no notice has been given to the appellant on the proposal of blacklisting of the appellant, your lordship. It was contended on behalf of the state government that there was no requirement in the rule of giving any prior notice before blacklisting of any person insofar as the contention, there is no requirement specifically of giving.
Yes, then I read it. Tell me.
Lordship, then your lordship, this is your lordship. One more judgment, your lordship, it is 1989, 1 SCC 764, your lordship. And also I am relying on that judgment, your lordship, media one, where your lordship, before taking any action, your lordship, adequate opportunity is to be given, your lordship. Or your lordship has already gone through that judgment, your lordship. There are 35 onwards. Your lordship. And one aspect, your lordship, will kindly note, your lordship, in the first inquiry report, your lordship, that I wanted to show, your lordship, where, your lordship, I was present, your lordship. They have annexed this in their read.
Yeah.
Page 65, your lordship. Your lordship will kindly come to page 66, your lordship, of my petition, your lordship. Why, your lordship, I should have got an opportunity to, your lordship,
Eight
the page 66,
of
following of the affidavit in opposition.
Ah.
Following are the noteworthy points, your lordship. The tanker chambers were found to be covered with box type arrangement. After opening the lock, each chamber box was opened and water was found inside all the boxes. The water was assumed to be accumulated inside the chamber box on the top of TTL due to heavy rainfall in the area and absence of any draining arrangement, your lord. Now, this was a finding of that same inquiry report, your lord. Same inquiry, physical verification, your lordship. Only after this, your lordship, detailed inquiry was conducted, your lordship. If that finding is there, your lordship, that is why, your lordship, I should have got an opportunity to, your lordship, counter the findings of the detailed inquiry report, your lordship, by which they have arrived at certain findings, and also to say that, your lordship, why the maximum punishment of blacklisting should not be imposed on me, your lordship. That was also a right, your lordship, on my part, your lordship, to argue before the authorities, your lordship, to place contention before the authorities that this is the highest punishment they are imposing on me, your lordship. That is not proportionate, your lordship. That chance also I did not get, your lordship, in the process, your lordship. Presence of only the driver, your lordship, and your lordship, had it been their case that at once they have issued this inquiry report to me, your lordship, then matter would have different, your lordship. This is the first inquiry, your lordship, physical verification and sampling. Sample is collected, your lordship. And on the basis of collection of the sample, a detailed inquiry was conducted based on which punishment was inflicted on me, your lordship. Now, in my humble submission, your lordship, in view of that, your lordship, and in view of the fact that a maximum punishment of blacklisting was imposed on me, with further recommendation of making other prayers, your lordship, other punishments, your lordship, I should have got an opportunity to place my facts, your lordship. I want that much, not more than that, your lordship. It is not my case that, your lordship, should enter in the merit of the case, your lordship.
Mr. Bhattakur, I
No.
think that is enough. The instant writ petition has been filed by the petitioner challenging the order dated 3/7/2019, whereby the Indian Oil Corporation Limited, through its Indian Oil Corporation, whereby the respondent Indian Oil Corporation Limited blacklisted the petitioner along with its crew for 2 years with effect from 3/7/2019 under clause 8.1A/1 Roman 1 and clause 8.2.8 of Oil in the Industry Transport District Guidelines. Bracket ITDG. The facts involved in the instant case is that a show cause notice was issued to the petitioner on 11/5/2019, thereby asking the petitioner to show cause within 15 days, why the petitioner should not be placed in the holiday list and be debarred from entering into any contracts with Indian Oil Corporation Limited, be not delisted from the list of approved vendors, contractors of Indian Oil Corporation Limited. The reason for issuance of the show cause notice was that on 9/5/2019, SRN TTL number NL02Q5450 entered Digboi refinery for unloading the SRN, which was dispatched from Guwahati refinery on 24/2019. During routine checking of the vehicle, the high dense quantity of water was observed on the top platform box. The vehicle was detained and subsequently checked in presence of the driver on the next day, that is on 10/5/2019. Upon checking again on 10/5/2019, with deep rod, and it was found in the TTL's chambers. That there was quantity water content in chamber number 1, 2, and chamber number 4. It was further mentioned in the said show cause notice that the petitioner was given the liberty to submit all supporting documents upon which the petitioner would like to rely upon. And if the petitioner failed to submit the reply, it would be presumed that the petitioner had nothing to say. Thereupon, on 14/5/2019, a reply was submitted by one of the partners of the petitioner. In the said reply, there was no denial to the fact that there was no water in the chambers, which was found on physical verification. But the reason assigned therein in the reply was that on account of Cyclone Fani, FANI, a large number of rainwater got accumulated in the inside of the dome covered box. And as the drain outlet of the dome covered box was not working due to blockage, a considerable amount of water got leaked in the 3 chambers of the oil tanker through the gas hole, resulting in water spillage. It was further mentioned in the said reply that as per the information given to the partner of the petitioner by the driver, the said was not intentional or deliberate, but resulted by circumstances beyond their control and comprehension. Pursuant thereto, it reveals from the records that an inquiry was conducted pursuant thereto, it reveals from the records that a committee was set up to investigate the matter. Full stop. The committee which was set up submitted a report on physical checking of the vehicle on 25/5/2019. It appears from the records, it appears from a perusal of the said committee. From the report dated 25/5/2019 enclosed as Annexure R4 to the affidavit in opposition filed by the respondent IOCL. That there were various members, including the representative of the petitioner. The said report which was given, the said report which was submitted, had further confirmed that there was water content in chamber 1, 2, as well as chamber 5. Which was also there in the show cause notice. However, from the said report, it transpired, from the report dated 25/5/2019, it showed that the water content in chamber number 1 was 15.7, which was otherwise 15.5 in the show cause, semicolon. In chamber number 2, it was 3 cm, which was 2 cm in chamber number 2 in the show cause. And in chamber number 5, it was 3 cm, which was 2 cm in the show cause notice. It was also opined in the said report that the weight of the vehicle before draining of the water from inside of the chamber was 29.770 metric ton, and the weight of the vehicle after draining of the water from the inside of the chamber was 29.440 metric ton. In clause number 9 of the said report, it was observed that the test results of Guwahati refinery and the Digboi refinery were not matching, and for which a detailed analysis and report was directed to be submitted by the committee shortly. Thereupon, the said committee submitted a report on 30/5/2019. The conclusions mentioned in the said report is at clause number 6, which is being relevant is quoted herein under, reproduced herein under, page 76 of this. It further reveals that thereupon on the basis of the said report, on the basis of the two reports referred to herein above, on 3/6/2019, the CPNM bracket OMNS bracket close had circulated an inter-office memo for taking appropriate action, penal action against the petitioner. Pursuant thereto, on 3rd of July 2019, the impugn order was passed, whereby the petitioner was blacklisted for 2 years with effect from 3/7/2019. Next. Although the impugn order dated 3/7/2019, as already stated herein above, the order dated 3/7/2019 has been only put to challenge. And a perusal of the said order dated 3/7/2019 only show that the petitioner has been blacklisted for 2 years with effect from 3/7/2019. Today, when the matter has been taken up, the period is long over. Next. Be that as it may, the learned counsel for the petitioner submits that the said order dated 3/7/2019 was passed in violation to the principles of natural justice. This court finds it relevant. Take note of. That a perusal of the pleadings in the writ petition would show that the ground for violation of the principal justice has been taken. On the ground that the show cause notice did not mention that the petitioner would be blacklisted. Be that as it may, the learned counsel, Mr. S. Botakur, appearing on behalf of the petitioner, had further developed the case, tried to develop the case on behalf of the petitioner by taking support of certain enclosures which were part of the affidavit in opposition filed by the respondent, IOCL. He submitted by making a reference to Annexure R4 and Annexure R5 and submitted that this report, which was given as Annexure R5, that is dated 30/5/2019, was a report made behind the back of the petitioner. And the said report ought to have been furnished to the petitioner before taking the steps, before passing the impugned order of blacklisting. That's your submission. He further submitted that in support of the submissions, the learned counsel for the petitioner had placed reliance upon the following judgments. You gave 3 judgments, no? Where is the second one? Which were, number 1, Raghunath Thakur versus the state of Bihar and others, reported in 1989, 1 SCC 229. Then
the other one you wrote, booklet you wrote.
this media one, no more. As well as the judgment of the Supreme Court in the case of, it's reported, as well as the recent judgment of the Supreme Court in the case of Madhyamam MADHYAMAN Broadcasting Limited versus Union of India. The date of the judgment. Reported in 2023 SCC Online SC 366. Yes, what is your submission?
Okay. From the Honorable Apex Court in the judgment of Eurasian Equipment Lordship, it was held.
Eurasian.
Yes, Lordship. It was held that the SOCOS is a mandatory requirement, and accordingly, in terms with the state judgment, paragraph 20, Lordship, the SOCOS was issued. And thereafter, what happened? Only after SOCOS was issued on 11/5/2019, Lordship. Thereafter, the petitioner was asked to appear before the committee. He has, citing his personal reason, he has authorized his driver. And thereafter, only to make out a case on 20/5/2019, he has filed an FIR, Lordship, before the Nunmati police station, stating that his driver is missing. On 11/5/2019, the SOCOS was issued. On 25, case 42 is the FIR, Lordship.
On the other hand, Mr. K. Kolita, appearing on behalf of the IOCL, submits that before taking any action, of blacklisting, the only requirement is to give a show cause notice, which was duly given on 11/5/2019. And thereupon, after taking into consideration the reply which was being submitted, a committee was formed wherein the representative of the petitioner was a party to that, as could be seen from the report dated 25/5/2019. He further submitted that the subsequent report dated 30/5/2019 are the definitive findings on the basis of the evidence so collected in pursuance to the initial report dated 25/5/2019. That's your submission
Yes, Lordship. That was signed by his driver. Case 67 last.
of 25/5.
Yes.
He further relied upon the judgment of the Supreme Court in the case of MS Eurasian Equipments and Chemicals Limited versus the state of West Bengal and others, reported in 1975, 1 SCC 70, wherein it stated wherein it was held that prior to entering it, prior to blacklisting, prior to passing an order of blacklisting, the contractor has a right to receive a show cause and to submit a reply thereupon. He further submitted that this court is exercising a jurisdiction under Article 2 to 6 of the Constitution. And as such, the jurisdiction so exercised is only to look into as to whether the decision-making process is arbitrary, illegal, or unreasonable, or have caused manifest injustice, which is, however, not the case in the present, however, not the here, no, and manifest injustice. The learned counsel for the respondent further submitted that as in the instant with petition, only the blacklisting order has been put to challenge. And the said blacklisting order having spent its force, the instant with petition has become infructuous. I've heard the learned counsels for the parties and perused the materials on record. Before dealing with the facts involved, this court finds it relevant to take note of the judgments so placed by the learned counsels for the parties. As already stated herein above, Mr. S. Botaku, the learned counsel for the petitioner, had submitted the judgments in the case of Raghunath Thakur Supra as well as Madhyamam Broadcasting Limited Supra. In Raghunath Thakur Supra, the Supreme Court, at paragraph number 4, was dealing with a situation where a blacklisting order was passed without issuance of any notice. And it is in that regard, it was observed by the Supreme Court that blacklisting any person in respect of a business venture has civil consequences for the future business of the person concerned in any event. And it is elementary principle of natural justice that parties affected by any order should have a right of being heard and making representation against the order. Next. In the case of Madhyamam Broadcasting Limited, the Supreme Court made an elaborate discussion as regards the requirement of you are referring to which paragraph here?
Paragraph 35.
Paragraph 34, huh?
What?
42. 42. Duty to act. Continue. Where the Supreme Court had made an elaborate discussion on the principles of natural justice and as to when judicial review is permissible on procedural grounds. Paragraph number 47 of the said judgment, that is otherwise 42 in your. Paragraph number 39 to paragraph number 47 of the said judgment details out the principles of natural justice, its purpose and the content. It was observed by the Supreme Court in the said judgment that the principles of natural justice were read into the law and the conduct of judicial and administrative proceeding with an aim of securing fairness. It was further observed that the principle 6 of natural justice seeks to realize the following 4 purposes. Number 1, a fair outcome. Number 2, inherent value in fair procedure. Number 3, legitimacy of the decision and the decision-making authority. Number 4, dignity of individuals. The Supreme Court further in the said judgment also explained the constitutionalizing principles of natural justice, which was brought into the fold under Article 14 and 21 of the Constitution in the judgment of the Supreme Court in the case of Maneka Gandhi versus reported influence. In paragraph number 53 of the said judgment, the Supreme Court further explains the impact of the judgment of the Constitution bench in the case of Maneka Gandhi Supra on the procedural fairness because of constitutionalizing of natural justice. The said paragraph 53 is quoted here in below. From a perusal of the above quoted paragraph, it would be seen that constitutionalizing the principles of natural justice would lead to a procedural fairness as well as breathe reasonableness into the procedure. It was, however, observed by the Supreme Court that while situational modifications, it was also observed by the Supreme Court that the facet of audi alterum partem encompasses the components of notice, comma, contents of the notice, comma, reports of inquiry, comma, and the materials that are available for perusal. It was further observed that while situational modifications are permissible, the rules of natural justice cannot be modified to suit the needs of the situation to such an extent that the core of the principle is abrogated, because it is the core that infuses procedural reasonableness. It was further mentioned that it is the burden upon the applicant to prove that the procedure that was followed, bracket, or not followed, bracket close, by the adjudicating authority, comma, in effect, comma, infringes upon the core of the right to a fair and a reasonable hearing. In the backdrop of the above principles of law as stated, let this court take into account the facts involved. On 9/5/2019, during a routine checking, high quantity of water was observed on the top platform oblique box of the vehicle of the TTL. What is this TTL? Transport? Yes, you are the owner of the TTL. Tell me. And you want natural justice. Find out. Okay.
Transport truck, your lordship, TT means transport.
And
truck.
then L is
that's your lordship.
of the TTL.
Thank,
Under such circumstances, what was found out during the said routine inspection and why action should not be taken against the petitioner? A show cause notice was issued on 11/5/2019. The petitioner duly replied to the same on 14/5/2019, duly admitting that there was water content in the chambers as alleged in the show cause notice. However, it was the case of the petitioner that it was on account of the cyclone Fani. A large amount of water, rainwater got accumulated in the inside of the dome covered box. And the drain outlet of the dome covered box was not working due to blockage, for which a considerable amount of water got leaked in the 3 chambers of the oil tanker through the gas hole, resulting in water spillage. And it was not intentional or deliberate. Taking into account the said reply, a committee was formed on 15 2019. When the said committee was taking up the physical checking of the TTL of SRN TTL, the vehicle of the petitioner, the representative of the petitioner was duly present. And on the basis of the said findings so arrived at, on the basis of the physical checking, physical verification findings, the preliminary report was given on 25/5/2019, and making it clear that the final report would be submitted by the committee. The representative of the petitioner was duly present therein also and signed the minutes dated 25/5/2019. And thereupon the report was given. And on the basis of the report was given, whereby the conclusion so arrived at, report was given on 30/5/2019, and the conclusion so arrived at have been already quoted supra. It is thereupon, on the basis of the said reports, the impugned order dated 3/7/2019 was issued. The facts above mentioned, and taking into account the law so laid down by the Supreme Court, it is the opinion of this court that the procedural fairness as well as the reasonableness of the actions cannot be called into question. This court is of the further opinion that the petitioner had also failed to show that the procedure, if any other procedure would have been followed, the petitioner could have justified the findings of the report dated 35/2019. This court is also of the opinion that the petitioner have failed that a followed procedure by the respondent authorities in effect infringes upon the core right to a fair and reasonable hearing. Under such circumstances, this court finds no reasons to interfere with the impugned order. Stay was there.
No, Lordship, no. But subsequently, Lordship may peruse the order dated 22/8/2019.
Interim order was there, some interim order.
22/8/2019. Lordship, regarding blacklisting, no stay order, but
No cause. There is no stay order on the blacklist.
TTL means tank truck lorry load.
The interim order so passed on 22/8/2019 that no coercive action should be taken against the petitioner. Hence also vacated. Accordingly, the writ petition stands dismissed. Cost. With cost, which is, cost. 50,000.
Lordship, I am coming with your lordship. I have filed writ petition, Lordship. I have not, your lordship,
Cost.
hide anything from this honorable court. Your lordship. The genuine prayer I have made, your lordship may not
No,
accept
no.
my.
There is not a genuine prayer out there. You have got the thing out here. Okay, all right. Stands dismissed. Pending applications, if any, also stands dismissed. I have also stands closed in terms with the above judgment. I
Lip. Outlet. TTL.
We have received the inquiry report, Lordship, and affidavit is also ready, but that it is sent for backing. Inquiry report against the respondent number 5,
Then
which was done by CDPO. We have received that inquiry report.
who is the petitioner?
Pavitra Nath,
That I know. How is she involved?
respondent number 5,
Petitioner.
his grandson is registered as a student in the Angarwadi.
You are a resident out there.
Yes, local.
And there is some allegation or against respondent number 5.
Yes, she has not been attending the center since her marriage. And so also grievance also raised by the local public, including the petitioner for misappropriation of fund and food supply. So with that, all this, they had filed 2 applications before the annexed 2 is the communication done by the district social welfare officer to CDPO, concerned CDPO, to take proper action and file the report.
Then
Then nothing has till today happened. We have not received anything or no action, nothing.
But madam, tell me one thing. This Anganwadi center, isn't it required to be functional? Isn't it required that the Anganwadi center should remain functional? Seems that you have closed it down.
No, Anganwadi, according to the report, that Anganwadi center is running.
It's running still.
Yes,
And
and respondent
the-
number 5 is also working.
is working. What has happened in the inquiry so found? So there is nothing against the petitioner, respond number 5.
Yes.
These are false complaints to disturb the petitioner. Respond number
respondent
5 to
five.
function. The instant writ petition was filed by the petitioner who is the resident of 1 Anganwadi Center number 157 under Katilasera ICDS project Hailakandi, seeking a direction upon the respondents to ensure opening, public functioning of the Anganwadi Center and to serve food regularly to the enrolled children of the Anganwadi Center, as well as to inquire about misappropriation and misappropriation by the respondent number 5. This court had issued notice on (28 to 2022). By the said order, this court further directed the respondent number 3, that is the district social or welfare officer Hailakandi, as well as the respondent number 4, the child development project officer Katlisara ICDS project Hailakandi, to place the relevant inquiry report regarding the allegations lodged by the petitioner against the respondent number 5. Mrs. S. Purva, the learned counsel appearing on behalf of the respondent number 1, 2, 3, and 4, had placed before this court an inquiry report submitted by the supervisor sector 10 Katlisara ICDS project Hailakandi to the child development project officer, wherein it has been mentioned that she had met the guardians of the children and the beneficiaries who are available during inquiry, and AWC managing committee and public representative (AP) member of the locality, and inquired about the performance of the AWW about the performance of the respondent number 5. During the inquiry, it was found that the respondent number 5 was performing her duty, role, and responsibility as Anganwadi worker very sincerely and fairly after her engagement till date. It was also found that there was no complaint against her functioning as an Anganwadi worker, and all the available guardians of the children and local public and also the Ansalik Panchayat AP member of the area were satisfied with the work of the respondent number 5. Certain photographs have also been enclosed to the said inquiry report, showing that the guardians of the children along with the wife of the petitioner were receiving the, what is this THR? Were receiving the benefits allotted by the government. It was further mentioned that once Sapon Kumar Das had filed a complaint earlier before the Deputy Commissioner Hailakandi against the respondent number 5. And in respect of his complaint concerned AWCMC and the local public had submitted a petition before the CDPO Katlisara ICDS project that the said Sri Sapon Kumar Das falsely filed complaint against the respondent number 5. And also AWCMC stated in their petition that the said Sapon Kumar Das always disturbs and threatens the respondent number 5. It was also mentioned in the report that the said Sapon Kumar Das along with the petitioner are collusively filing complaint against the respondent number 5 due to previous enmity. Taking into account the said report, which is also being endorsed by the Child Development Project Officer, this court finds nothing, finds that the writ which has been sought for by way of the instant writ petition, taking into account the above reports, this court finds no reasons for issuance of a writ in the instant case, for which the instant writ petition stands dismissed. The report so submitted by Mrs. S. Bolwa is kept on record and marked with the letter X.
Can I get a copy of?
I have one copy of it.
The petitioner would be at liberty to take certified copies of the report of the documents enclosed as annexure, the documents marked with the letter X.
Item 7.
Yes, what is this?
By last order 22/5/2023, the respondents number 3, 4 and 5 were directed to take necessary instruction upon the notice issued by them on 1/2/2018, by which a stop construction focus notice was issued, but thereafter no final order was passed.
Who are you?
I'm the person whose house is behind the house of the private respondent. And as per the deed of compromise, there was a common path which was made by the private respondent. And this common path, while they apply for the building permit, in your lordship, that was not shown in their site plan. So we accordingly informed the GMC authorities that as per law, they are bound to show the site, the common approach road, which is leading up to my land. And accordingly, GMC issued the stop construction notice. But subsequently, your lordship, nothing has been done. So my only grievances before your lordship is this, is that even if their building has, and on the day when I filed the writ petition, only piling works were carried out. Presently, what my client informed, they have raised a construction of G+3. It's G+3.
G+3.
Yeah. Presently, what I have been in. So construction is going. My only grievance is that they have shown that common approach road, which is over which none of the parties agreed not to claim any right title in it. By showing as their own property, obtain a setback side margin and constructed that property. Now, your lordship, third party interest will be created. My house is situated behind, it's on the back side of it. I have no access other than that approach. So if the common approach road is only shown in the site plan, I have nothing to say. Because as per the mandate of law, your lordship, the regulations, the private respondents were bound to disclose that common approach because it's a means of access to my plot plan. So they were bound to disclose by submitting the plans before the GM. So we raised complaint, and GMC authorities were duty bound to, while granting the permission, to see whether there was a path or not, which has been shown on in respect of the land abutted to the land of the private. That is the grievance.
So you say that there was a mutual compromise at one point
Yes.
on which there is a private path.
Yes.
Now, while taking the building permission and getting the approved plan, that private path is not being shown.
Yes.
And under such circumstances, you apprehend
Yes.
that you will be affected at a later point of time if there is some construction carried out.
Construction is already carried, or not on that common path, Your Lordship. Suppose, Your Lordship, we agreed that no right had interest over that common. Now, if the subject to correction, Your Lordship, if any permission is required to be obtained, then leaving aside that common path, the setback side margins has to be done for construction. Now, what they did, that while obtaining
Common
the
path
permission,
is in whose name?
presently, as per the deed of compromise,
In whose
in,
name?
in the name of the private.
So it is a dispute between you and him.
No, Your Lord.
What is that?
Your Lordship,
No, can the JMC take into account anything else as part in law?
yes, Your Lordship. If Your Lordship peruses their affidavit in opposition annexure 1,
Who?
GMC filed by the
Siddhartha Goswami.
Yes.
What does it say?
Your Lordship, this is a show cause notice for stop construct.
Hmm.
And there, Your Lordship, it comes to point 2. There is a road,
Point which one?
annexure 1, page 5 of the affidavit in opposition filed by respondent number 1 and
Thereupon what happened?
nothing happened. This is dated 1/2/2018. We filed the writ petition in 2020. In the affidavit in reply, Your Lordship, at paragraph page 4 of the affidavit in reply, para 8, last line here, the final order is also put up, but nothing happened. When I filed the writ petition, filing work, the photographs are there.
Where is the private part at annexure 2 of your this thing? Document? Additional affidavit you have filed.
No, Your Lordship. Oh, yes. Additional affidavit I have filed.
Annexure 2.
Your Lordship, more clear photographs is in the writ petition. It's a color photograph.
No, this is also colored. Annexure 2 of the
yeah.
additional. Then why did you enclose at all?
No, it's there. This side one, but there I have marked it up. This is the private part. In
So
the writ
what is
petition,
wrong?
no, while obtaining, Your Lordship, they are bound to disclose this as a common path while obtaining the building permission.
So
So if they don't do, and
they
the
have
GM,
stopped the construction. You have
Yes.
stopped the construction.
Thing is that the notice has been issued, my lord, under section 388.
Now you have issued a notice under 338.
338, my lord. And
Then
compromise deed was of March 2015. Thereafter, they got the permission in 2018, 2016.
Hmm.
And the road, that particular road has not been shown. That is the issue.
then
That is
what
the
are you
shadow.
doing?
I need to take the instruction, my lord. Why that action has not been taken since 2018.
now this is the present day, Your Lordship, photograph. The building has come up. When I filed it, only filing work, the photographs are there. I prayed for the interim order, but the order was passed that it will be subject to outcome of this writ petition. Still going.
No. You see, whether it is private part shown or not, how does it make a difference?
Because the law mandates, Your Lordship, while submitting a site plan, they have to show the means of access. They have to show every lane, every road. They are bound to.
Okay, if they don't show, what is the
Now,
consequence?
if the person concerns will come and will sell it off. Suppose if they sell it off, the property.
So how does it matter?
Now, Your Lordship, suppose I will take it to another, like if this private part is not shown. Now the question is a setback side margin. So setback side margin, from which point it has to be calculated. So it's a 14-feet road. So now if they are constructing by showing it as a setback side margin, but not showing as a road, there is a deviation. Because then they will, as per law, after leaving aside that common path, they have to show the setback side margin. So there is a clear-cut deviation. Other than that, section 338, Your Lordship, it amounts to material suppression of material representation before the authority concerned while obtaining the NOC.
You are paying for?
And
Yes, what
second-
has happened?
My lord, the only thing I take your lordship to the compromise decree, my lord. There was a compromise decree, my lord. Your lordship
Where?
can kindly comes, the agreement starts at page 38.
I take your lordship to page 41, madam. Clause number 1, my lord, that the second parties do hereby agree that they will provide a road oblique path over the schedule B land measuring 14 feet in breadth so and so in the southern boundary of the schedule B land. It is specifically described as schedule D. Now, clause 2, my lord.
No,
the
no,
sched-
wait. The second party, you.
lord, everything will be clear from the drawing, my lord.
Road path over the schedule B land, measuring 14 feet in breadth and 120 in length on the southern boundary of the schedule B land, and which is specifically described to be and shown in the map enclosed.
Page 46.
Yeah, then
Then everything becomes clear, my lord. The only issue is, my lord, that whether I am using this land or I am encroaching upon this land. If this land is shown as the setback, and if it is not encroached upon, and if he has the access to that land, my lord, I don't think he should have a grievance, my lord. So let the GMC make an inquiry. Because he has submitted by my learned friend that if that land is not encroached upon or no third party right is created, he should not have a grievance. Because the only agreement is that clause 3
is
again
this a
comes.
compromise deed or a compromise decree?
This is a compromise deed, my lord, pursuant that a decree was passed
on the basis of this.
on the basis of.
So it's a decree.
It is a decree.
It's a decree after.
It is a decree.
That is annexure 5. Lord.
Huh?
Decree is on annexure 5, page 47.
Clause 2 of page 41, my lord, if your lordship kindly takes up. Schedule D land will be common for both the parties here, and both the parties shall never claim any right title interest over the schedule B so and so, or
Schedule
raise
B
any
land
type
will
of
be
concern.
common for both the parties and no right title interest is
Right title
claimed by
interest.
both the parties over it except the right to
Title.
use. Both parties have raised any type of
Construction
over the tell no, what is this?
or
Okay.
raise any type of construction over the schedule D but except right of user.
Let us see what does the both parties never never raised any construction. Yes. So what is wrong with you? You see, he won't raise any construction over the schedule D land.
No, but he is claiming right over the property by showing his as
Go
it
to
is
the
own
civil court.
property.
This is not the court for this.
No. Your lordship, one thing, if your lordship will be allowed to place certain provisions of the GMC Act. Because if a person violates the mandatory provisions of law, the Honorable Court will look into those matters. Honorable Court will not allow the other person, because my learned friend has not denied the fact that this common path has not been shown in the approved plan. And if it has not been shown, so whether it violates the provisions of law, and if it would not have violated, because I will take this on court to the provisions of law. Otherwise, why the GMC would have issued the stop construction note?
Where is the stop construction?
The affidavit in opposition, the show cause, sorry. Show cause to the stop construction.
Then?
If there is a violation, then only show cause stop construction notice has been found. So now provisions which mandate them to show the site plan. First, your lordship, in the writ petition by way of RTI, page 80 is the site plan, which is there. From there, we came to know page 80 here. It's on the southern side. The approach road has not been shown. Your lordship got. Then page 92, your lordship, is the photograph of page 90. The position of the land of the party.
No, why should this court exercise 226 here in this matter?
So,
Whatever may be, that is the way. If the GMC is not doing it, go before the civil court.
your lordship, GMC is the
Why
statutory
should this
authority.
court at all exercise the jurisdiction? Whether you have a right to file a complaint to the GMC. The GMC's so-called notice is on the basis thereof. Why should this court
So-
intermingle amongst the fight between you and him
So there is
and involve the GMC out there?
no, the GMC, your lordship, the path is there. And GMC Toko's notice shows that the path is there and which was not shown. Now, how the GMC will be intermingled? Your lordship, the provisions which is governed is the Guwahati Building Construction Regulation Act 2010. And it defines road. Road is defined, your lordship, at section 2, subsection 30, which means any path, public or private. Now, while
It's a
submitting,
private, it's a private part.
yes,
The land still belongs to the petitioner.
yes,
Only that he won't raise it.
so
That's
he,
all.
he relinquishes right over the.
No, he has not relinquished his right.
Your Lordship,
He says that he is not going to raise any construction over.
Your Lordship, earlier there was a part in between. Now,
And if there is a violation to the compromise decree, go for
there is
execution.
no violation to the compromise decree.
Then what is wrong?
But the
Yes, Mr. Bora, tell me one thing. If the land belongs to him, he says that he is not going to raise any construction over it. That's a compromise between him and him. It's not. But whether it is a road or not, whether it is mentioned as a public path or not, how does it materially affect the building permission?
Will not affect the material.
Go.
Because that-
It cannot affect the building permission. He only cannot raise the construction, and if he raises, then obviously that authority will, the civil court, the compromise decree will be put to execution.
No.
That's another thing. For that, a permanent injunction may be given, or whatever may be, that can be passed, or execution can be granted for that. That is another thing. But how can the GMC, as of now, on records, it is their land? Can you say that is not their land?
No, that cannot be my. That compromise deed is actually clear, my lord. Only that access is being given.
And where
Unrestricted.
are you, where is it necessary, Mr. Rai, kindly tell me that if it is a public path, it's a private path, you have to mention it.
yes, Your Lordship.
If
will
it's
please
still,
to-
if it is a private path,
Yes, yes, Your Lordship will please to come to section 2, subsection 32 of the Building Construction Act.
yes, what does it say?
Guwahati building, it defines road, first of all. It says, means and includes any highway, street, lane, pathway, LA passage, carryway, footway, square bridge, whether private or public, whether thoroughfare or whether existing. So definition includes, Your Lordship, private and public path.
Show me where, what is the name?
The building, Guwahati Building Construction Regulation Act 2010.
2000,
Page will be 570.
570.
Yes, Your Lordship.
Yes,
So this is the act, Your Lordship, section 2, subsection 32 defines road.
subsection, yes, road means includes any highway, street, pathway, so or not, whether existing or proposed in any scheme. Okay, then,
So private right road is there, Your Lord.
Hmm.
Now, Your Lordship, this to come to, they have to obtain planning permit and building permit.
Hmm.
Now, Your Lordship, this to come to section 5, subsection 7.
yes,
So I will take this on go to site plan, which is needs to be submitted. I am just submitted before this on court.
site plan shall be drawn in a minimum scale of 20, the boundaries of the site with dimension area, the road position of the site in position of material. Then,
Then building plan, Your Lordship, A, it also shows complete layout of the area and area showing location and width of all streets, dimension, size and use of all plots. So if the use of all plots is there, so this is a common approach road, which has been agreed as per the deed of compromise. And as per the deed of compromise,
no, there is an approach.
that's a common approach road.
No, there is an approach to his place.
No, my place,
So we are not concerned with your place. We
No.
are concerned with his place.
but that
No,
part,
does he have an approach
No.
from that road?
Your Lordship, that road now no longer remains his land. Your Lordship, if.
The land always remains his land only.
No, Your Lordship. I
So
have to take-
can by way of a decree,
Your
Okay.
Lordship,
can, no, Mr. Rai, kindly show me, can by way of a decree, somebody may say that this is not my land?
Your Lordship, by way of a decree, parties
Yes.
agreed. Because Your Lordship, if Your Lordship just comes to the, means what has happened in this case, because Your Lordship has rightly opined that if any construction raises, then my right accrues before the civil court. But presently, I am before this Onmo court against the inaction done by the GMC. Now, this Onmo court raised the question whether GMC should be bordered or not, whether this is
Yeah.
a private land or not. So that is what I am submitting before.
Hmm.
When the GMC Act provides that the petition, the respondent private concerns were bound to disclose the LA or any street or path, your
Hmm.
lordship.
Hmm.
How it is not in statutory violation.
Hmm.
Further than otherwise, your lordship, because the main thing is the setback side margin. That will change, your lordship. How can GNCP not be concerned? If it's a path which cannot be used subsequently as a parking space, because it's a path, my right infringes, it's a different issue. I will go to civil court as and when it infringes. But present, the question before this, before your lordship I'm posing is that why the GMC is not acting? It's a path is there, the drainage is there, it's a path is there, it's a visible path. How can it be used as his land by showing the setback side? Why the GMC is not acting?
No, he can't use it.
They are using it as no.
No, he's not using it. Is he using it?
Yes,
How?
they are also using it by
No,
showing
no, no, no. Is he using it for the purpose of construction?
your lordship. Yes, for the purpose of construction. If I
No,
may
he is
submit,
not.
your lordship, that land will from the boundary wall, the setback side margins will be done.
Mr. Rai, go to the civil court or
Your lordship,
this
if
court,
he right,
this
right in-
court closes the entire thing on behalf of the GMC.
your
What
lordship,
do you want?
I will make my submission, your lordship.
Yeah.
Because
I have considered
so that
the instant repetition has
your
been
lordship,
filed.
allow me to point.
No,
out
no,
the-
enough. Your
Your lordship,
No, no, enough.
provisions of law, your lordship.
No,
I have
not
put.
necessary. All provisions of law are there before the division bench to be received.
Your lordship,
The instant repetition has been filed.
just allow me
by
the
the
two
petitioner.
more provisions to submit
No,
on two more.
nothing doing. The instant petition has been filed by the petitioner.
Your lordship,
challenging
I will not interfere. Just one
The
thing I would like to
building
submit.
permission issued by NOC number GPL oblique BP oblique 16/120 oblique 270-12016 oblique 104 oblique 149 dated 28/10/2016. Granted in favor of the respondent number 3 to 5. From a perusal of the petition, it transpired that a deed of compromise, that a suit was filed between the predecessor in interest of the petitioner with against by the predecessor in interest of the petitioner against the respondent number 3, 4, and 5. Along with one Srimati Golapit Talukdar. The said suit was registered and numbered as title suit number 316/2014. It appears from the records of the petition that a compromise, the deed of compromise was entered into on 31st of March 2015 between the predecessor in interest of the petitioner with the respondent numbers 3, 4, and 5, along with 2 others. Although there are various clauses on the deed of compromise, but relevant to take note is clause number 1 and 2, which is reproduced hereunder, page 41 of. That said deed of compromise, to the said deed of compromise, there is a map The said deed of compromise was subsequently made a decree of the court on the basis of a joint application filed by the parties in title suit number 316/2014. The said compromise decree was passed on 31/3/2015. And the compromise deed of compromise dated 31/3/2015 was made a part of the compromise decree. It further appears from the records yes, Mr. Rai, come to page 80.
Okay, Your Lordship.
80.
Yes, Your Lordship.
Which is the road?
No road shown.
There is a road on the left hand side.
That is the main road.
Huh?
That is the main PWD road.
And where is that road otherwise?
Otherwise, Your Lordship, it should be from this side.
Hmm?
My land is behind, Your Lordship, land of Savitri Devi Goenka. It's shown. Actually, Your Lordship, in the original sale date, it was agreed that a 14-feet passage will be left. Subsequently, they blocked it after the suit was filed. In the sale date, it's mentioned that the 14-feet passage
South
will be
will
left.
be which one? North, south, east, west.
Your Lordship, this is this one. This is the south.
Huh?
This is the south.
This is the road is shown on the left hand
Yes,
side.
after the boundary, there is another road. There's the
After
lane.
that road, there is another road.
Yes, there is a boundary. Your
And
Lordship,
where is your house?
From the
Where is your house?
my house is behind.
Oh,
Your Lordship,
show it at page 80. Where is your house?
page 80, Your Lordship, it's shown. Just it will be on the. Your Lordship, my name is there. This is land of Savitri Devi Goenka.
On the
Behind.
back hand side.
Yes.
So what is this road? There's some
There is another road, Your Lordship. The color photograph will clear it. Page 90.
page.
Page 90.
Yes.
PWD road, Your Lordship, I have highlighted. Then there is a small private
Oh,
path.
this
Yes.
is your.
Yes.
This is your.
Then this road, common road, as per the deed of compromise, because the earlier road, as per the sale date, which was left out, 40 feet, he
Where
encroached.
is the road? Any other road on the other side? There's no other road.
Your Lordship, this one means
Next to it, there is no other road.
yes, that
Your road is with the blue gate.
yes,
Your house is with the blue gate.
blue gate.
So on the back side, it is yours.
Yes.
And then on this is the common road,
Yes, common approach road. Left.
common approach road. And on the left hand side is the construction
Yes,
on top.
yes, Your
On left hand side is the construction.
construct.
Now here, why you are saying that there is no road shown in the site map at page
Oh.
80?
This road is not shown. That is the schedule D highlighted in the site map. That has to be shown. That is my grievance.
No, it's okay. But where is your here? Where is your land? Page 80.
Your Lordship, backside is my land, land of Savitri Devi Goenka, and party as per the compromise. This is the path which I am supposed to use.
Which one?
This is the path I am supposed to use.
So that there is a road which is there.
Yes, that Your Lordship further will be clarified. Page 92, the photograph will show one car is parked.
Page
92, the photograph. That road is shown as road. The one car is parked here. That road they have shown. So basically, this road which is leading up to my house, that has not been shown.
लिख लेला सर. It further appears that the respondent number 3, 4, and 5 obtained a building permission to construct where's the building permission?
Copy is not with me, not served up.
You have a building permission? You don't have a building permission and you are constructing.
No, copy is not with me.
Then we demolish, direct them to demolish it.
The copy is not with me.
Then-
Building permission is there because they have, the number is there, madam.
Yes, your lordship,
They have
it's
issued a show cause as to why it should not be.
G+4, it is the basement G+4 as per the affidavit in
Because
opposition.
the page 90 is part of my building permission. Page 80, madam, sorry.
Yes. That is the site plan we are agreed.
80 is a site plan, 81 is that approved, madam.
The respondent number 3, 4, and 5 have obtained the building permission from the GMC authority on 28/10/2016. And along with the building permission, there is also an approved building plan. The petitioners herein subsequently, on the basis of a Right to Information Act 2005, came to learn that in the approved building plan, the common path which was agreed to in the deed of compromise was not made a part of the site plan, approved building plan. And as such has submitted a complaint to the GMC. On the basis of the same complaint so made, the Commissioner GMC had issued a notice under section 338 of the GMC Act 1971. Stating inter alia that the permission for the RCC building, that is BF plus GF plus fourth floor, was accorded by the NOC number GPL/BP/16/120/27016/104/1479 dated 28/10/2016. It was mentioned that there is a road within the length of the plot from eastern side to the western side, which was not shown in the site plan, which amounts to material misrepresentation of facts. And as such, the respondent numbers 3, 4, and 5 were asked to show cause within 7 days as to why the said permission accorded should not be revoked as empowered under section 338 of the GMC Act of 1971 on the ground of material misrepresentation of facts. It is the case of the petitioner that although the Commissioner GMC had issued the show cause notice on 1/2/2018, but the GMC authorities thereupon did not follow it up. And it is under such circumstances the petitioner has approached this court for cancellation or revoking of the GMC permission, GMC building permission, so accorded to the respondent numbers 3, 4, and 5. It appears from the records that this court had issued notice on 5/10/2020 . In doing so, this court had also observed that any construction made in violation of the construction permission, public norms, rules and regulation would be subject to further orders that may be passed in the proceedings. It further reveals from the records that the GMC authorities had filed an affidavit in opposition on 21/1/2021, wherein at paragraph number 3, 4, 5, and 7, 4, 5, 7, and 8, the GMC authorities have only mentioned about issuance of the show cause notice on 1/2/2018. 1/12, not a 1/2, 1/2/2008. But surprisingly, the GMC authorities are silent as to what action has been taken pursuant to the said show cause notice. It further reveals from the records that the respondent number 3, 4, and 5 appeared before this court by filing through their counsels on 25/11/2020. But no affidavit has been filed by the respondent number 3, 4, and 5. This court further finds it relevant to take note of that there is an additional affidavit filed by the petitioners on 20/5/2022. Wherein it was mentioned that after filing of the writ petition, the private respondents 3, 4, and 5 did not continue with the construction activities, but on and from the second week of April 2022, the respondent number 3, 4, and 5 have started works of construction, that is piling works, under such circumstances, the petitioners have yet again filed an application under in terms with the Right to Information Act, as to whether any revised plan have been submitted by the respondent number 3, 4, and 5, and as to whether such revised plan have been approved. The zonal engineer, as well as the associate planner of the Guwahati Municipal Corporation, had, in reply to the said request made under the Right to Information Act, had informed the petitioner that there has been no revised plan approved. I've heard the learned counsels for the parties Mr. A.K. Roy, the learned counsel appearing on behalf of the petitioner had submitted that the respondent number 3, 4, and 5 have suppressed the fact that there is a road, common path on the south of the land of the respondent number 3, 4, and 5. And this suppression of material fact and by suppressing this material fact, the respondent number 3, 4, and 5 have obtained the building permission, which is required to be revoked in terms with the provisions of the Guwahati Municipal Corporation Act 1971, as well as the Guwahati Building Construction Regulation Act 2010. The learned counsel for the petitioner further submits that by issuance of the notice dated 1/2/2018, the GMC authority, the commissioner GMC had categorically noted that there has been suppression has been misrepresentation, material misrepresentation. But the GMC authorities have remained silent for reasons best known, as could be even seen from the affidavit filed by the respondent number 1 and 2, wherein respondent number 1 and 2, which was filed on 21/1/2021, without stating as to what further actions were taken pursuant to the notice dated 1/2/2018. Anything else more than what you said?
No.
Yes. Mr. Endega, the learned counsel appearing on behalf of the respondent number 3, 4, and 5, had submitted that a perusal of the deed of compromise, as well as the compromise decree, would show that a common passage of 14 feet in breadth and 123.5 feet in length, which have been specifically described in Schedule D to the deed of compromise, would be provided to the predecessor in interest of the petitioner. He further submitted that the deed of compromise will also show that no party shall claim any right, title, and interest over the Schedule D road / path, or raise any type of construction over the Schedule D road / path except the right of user. Mr. Endeka therefore submitted that in the instant case, the respondent number 3, 4, and 5 are not raising any construction over the common passage, and non-disclosing of the common passage in the site plan would not amount to material misrepresentation. Anything more?
One only thing, my lord, may add, my lord, from the photographs annexed to the writ petition and the additional affidavit, it is also clear that I am not raising any concern.
He further submitted that from the photographs enclosed by the petitioner in his writ petition as well as also in the additional affidavit, it would clearly show that the petition respondent number 3, 4, and 5 are not raising any form of construction over the said common passage. Mr. As per the learned counsel appearing on behalf of the GMC submits that he has only instruction as regards the issuance of notice dated 1/2/2018, and thereafter no further instructions have been provided to him. Read. This court, upon hearing the learned counsels for the parties, have put a specific query upon Mr. A.K. Rai, the learned counsel appearing on behalf of the petitioner, as to how it would materially affect, how the petitioner would be affected if in the site plan, the common passage is not shown. The learned counsel for the petitioner submitted that the construction which is being carried out is a basement plus ground plus 4. And there will be third party rights involved. And at a later date, the respondent number 2, 3, 4, and 5, along with those third parties, may exert claim over the common passage, which would be contrary to the deed of compromise. Anything else?
And the provisions of the GMC Act, Your Lord, they are bound to disclose.
No, how is it relevant to you? I'm asking you the specific question. How would it materially affect you? You answer that.
Your Lord, if
That
it-
is that only
I
be,
don't-
you are not concerned with the setback. You can't be a
No, I am
concern.
not concerned with the same. My
So
only-
your only concern is
Yes.
that at a later stage,
If something happens, then I should not miss trouble. That is my only. So common approach. Road, if
So
any issue
therefore,
comes into that,
it is therefore the submission of Mr. A.K. Rai that the non-disclosing of the site plan, non-disclosing of the common passage in the site plan may at a future date affect the right of the petitioners over the common passage. You are not going to construct.
I cannot. I think it-
No. You submit a revised plan. Submit a revised plan
Or because
with the common passage. And they will
common
take them.
passage is shown in the setback panel. It's already shown because from page 80, if your lordship sees, the area appears to be much more than 14 feet. My lord.
No, you don't have that, the building permission. So we will assume that you entered appearance on 25/11/2020. And as such, no building permission has been brought.
No,
So we
building
will
permission is there,
suppose
my
that you have not shown,
lord. No,
as is on the doctrine
no.
of
Page
non-traverse.
80 and 81 is the building permission.
Where is the building permission?
Building permission number is there. 80 is part of the building permission. It is part of the sanction plan, my lord.
Understood.
Page 81, my lord, it is approved.
Approved, but where is the common passage?
But this is
And
the
this
common
is
basis.
where?
Here, my lord, this side. This side.
No, that is not the common, that is not the road. The road is on this way.
Road is not specifically shown, my lord. From the,
No, Mr. Dekka. You see, this building permission is not like this. It is on the other way around. The south is there. You see, remember the deed of compromise. The land of Savitri Das is on the south.
no, land of Savitri Das is on the west, my lord.
Savitri Devi is on
Savitri Devi is on the west.
Of?
West, my lord. Your lordship will take page 80 and 46.
Hmm.
Schedule A is Savitri Devi, my lord.
Where is schedule A?
on the top. So what is shown in page 80 is basically the bottom part of page 46, man.
Are you saying schedule A is submitted today?
That my learned friend will not dispute. 46, man, what? 46. Schedule A is submitted, I don't think my learned friend will
Yes, yes,
dispute that.
Schedule A is our land on the western side.
Submitted Devi is schedule A.
Schedule A.
And where is the common path?
Common path is there, is on the left hand side of page 80, my lord.
And schedule B
Your Lordship,
is what?
Schedule B is where the construction is going on. The proposed building is over schedule E, B,
Schedule B
schedule B. On the left hand side of the proposed building, my lord.
is on the west. So this is the west. So schedule B is the west.
Top
you
is
say-
west,
And
bot-
what is the length of the schedule D? 14 feet
14
in
feet.
breadth. So this will be the 14
That is not
feet.
discernible, my lord. I'll say that is not discernible from this.
No, this
sanction
is
plan.
14 feet in breadth and 123 feet in length. On the southeastern side boundary of the schedule B left.
If your lordship takes up page 90 also, my lord, parallel.
Schedule B left.
Alert na happen. Alert na happen. Come on,
oh, it- Thank you.
Schedule D is this at page 46.
Yes, my lord. If
So
your
this
lordship
is
takes
schedule
up
B
page
left.
90, my lord.
So this is the 14 feet road.
My lord, page 90. Lordship kindly takes up page 90.
Hmm.
The colored photograph. There is an arrow mark, my lord.
So that I have seen that.
That is the 14 path. And if your lordship compares page 90 with page 102, my lord, no construction is carried out on that part, my lord.
That I understand.
That is not, my lord.
But in the site plan, you have not given.
I have not shown it as a road, my lord. From
This is
it,
what I'm saying.
I have shown it in the setback portion.
Okay, if you don't want to do it, I'll ask them
No,
to
no.
take authority. That is your look.
That is the setback part, my will file.
Anyways,
Submit
next.
revised plan.
Leho.
No difficulty.
Then. Kill us. Mr. Endeka, however, submits that in view of the deed of compromise and the compromise decree, the respondents number 3, 4, and 5 would not raise any construction
Ma'am.
or claim any right over claim any absolute rights over the Schedule D plot of land, except the common rights as mentioned in the deed of compromise. This court had further put a specific query upon Mr. Endeka as to whether the petitioner, respondent number 3, 4, and 5, would submit a revised plan, taking into account that the taking into account the show cause notice which was issued, show cause notice dated 1/2/2018. The learned counsel for the petition, respondent number 3, 4, and 5 submits that the same is not necessary as can be discernible from page number 80 of the writ petition, which is the approved building plan.
But if need be, my lord, we can file it. No difficulty in that.
I said that is why I asked you. Then I
We'll-
could have closed.
We'll file it.
Now, otherwise I have to direct the GMC to further that investigation. You don't want to do it. That is why I say.
We'll file a revised plan.
Then
Only difficulty will be, my lord, that if the setback is now lessened, my lord, then there will be difficulty on my part. That is what I'm apprehensive about.
you explain it to them then.
Well, I'll file it. I'll file the revised plan showing the path. It will be up to the GMC to consider. I'll file.
Then itu nila submit as revised plan. Submits that it is not necessary in view of what has been stated in paragraph number page 80, which is the building plan. However, he submits that the petitioner, the respondent number 3, 4, and 5, in order to avoid any confusion at a later stage, is not adverse to submitting a revised building plan showing the common passage. Showing the common passage in a more clear and distinct manner. Upon hearing the parties and taking into account the queries, the answers to the queries so raised by this court is of the opinion that the only reason why the petitioner is aggrieved with the action of the respondent, inaction of the respondent GMC, is that the petitioners apprehends that at a later stage, the petitioners may be affected at a later stage.
If I miss what, now there is no approach road to my,
There's an approach route.
it is not shown. Now, if I want to demolish the old building, construct me, I have to show approach. That is also one.
That it submits that taken into consideration. That if it is shown, is apprehensive of the fact that if the common passage roads is not shown, the respondents number 3, 4, and 5 may claim at a later stage rights over the said land. The further apprehension of the petitioner is that if the said common passage is not shown in the building bylaw, in the approved plan, then at a later stage, if the petitioners want to demolish their existing building and reconstruct, it would be difficult on the part of the petitioners to obtain a building permission. In the opinion of this court, this apprehension could be settled by directing by giving liberty to the respondent number 3, 4, and 5 to submit a revised building plan within 60 days from today, thereby indicating the common passage, clearly indicating the common passage of 14 feet in breadth and 123.9 feet in length. This court further is of the opinion that if the respondent number 3, 4, and 5 does not submit the revised plan within the time stipulated herein, the GMC is directed to take appropriate steps in terms with the notice dated 1/2/2018 and bring to a logical conclusion the said proceedings within another 60 days thereafter. This court further observes that Anything else? Nothing. Taking into account the above, the instant writ petition stands disposed.
Can the first period of 60 days be made 90, my lord? Because it will also depend on the architect. Some time may be required.
You only need that road.
No,
Nothing
the
more than,
entire plan will have to be removed.
okay, 90,
Make it
90 and 60.
90 and 60.
Thereafter, you take
My
time.
lord.
From the date of the instant order,
Yes, yes.
a petitioner is given a direction to, petitioner is directed to serve a certified copy of the instant order to the respondent number. James is how much? Two?
One and
One and
No, no, two. Who is the James? Two. Commissioner
One,
is
one.
two.
Commissioner, James is
Two.
one.
Commissioner. James.
First body zonable code. Now, that instruction is not forthcoming. Now, my lord, so far as the second affidavit is concerned, filed by me on behalf of the chief secretary, I had at that time, my lord, secured the original record. And that document, my lord, that report, my lord, that is available in original. Now, in the, on 2018, that earlier affidavit which was filed on behalf of the chief secretary, that perhaps, my lord, instructions from the office of the chief secretary will have to be, my lord, called for, my lord. I have therefore secured the presence of my learned colleague.
So who is appearing for the,
My lord, my colleague will be appearing, my lord.
what is this two affidavits containing two different reports?
Report. But Lordship, might give me some time, my lord. I have come across the affidavit. It seems, my lord, the reports are different, my lord.
Friday.
Friday.
This is the matter on Friday,
Okay.
on which date Mr. D. Nath, the senior government advocate, shall apprise this court as to why the two affidavits filed with the chief secretary of the government of Assam contains two different reports, two different dissimilar reports.
But can it be on Monday?
Why?
Lordship, I'll just, because I have to.
This is a 2012 matter.
correct.
2011-12 matters, I don't even give an adjournment.
Lordship, I'll try.
As you are saying that you
I'll
have got it today, that is why
Yes.
I have.
Lordship, I'll try.
If you did not appear, I would have taken it right now.
No, I'll take. I'll take.
At number 8 to 10.
What is this matter?
The petitioners are landless people, they were selling a certain sort of land and government stopped to evict them. Then we made prayer for land settlement, my lord, and land settlement was given to us, but those the land which we were given settlement are swampy and marshy areas, not possible for habitation. So we made a representation that we given alternate land. But we have come to know that the land from which we are evicted are given allotment to other person. So our representative is there, it's our case.
The land which have been settled,
Which are-
where you are in possession, has been allotted to somebody else.
As per we have made allegation against yes, ma'am. To our knowledge, ma'am.
Yes, Mr. Bapuzari. You are settling them with some other land, and on the other hand, that land which you are settling, from where you are trying to throw out the petitioner, you are settling with somebody else?
My lord, that instruction, my lord, we will have
This is
to
very
come from the-
serious thing.
They are otherwise, my lord, settled with land. Now they
Understood.
have- they
No,
have
no,
made a-
understood.
Yeah.
They are in possession of some government lands. Now, it is your opinion that they are landless people for which you have given them a settlement in some other lands. Till there it is okay. There's nothing to touch on that. But if you are settling their lands where they are in possession with some other person, then it becomes Article 14, unfairness, unreasonableness, arbitrariness, everything takes into the fold.
Here with all respect, my lord, in these three cases, but affidavit from the deputy commissioner will be required because it is on tax. So lordship will have-
Why has the deputy commissioner not filed the
will
affidavit?
be Required.
Chief, kindly some time required.
Okay, 1 week time.
Okay.
File your affidavit. This is of 2020 max.
Yes, 2 weeks time. is fine.
File your affidavit by 11th of September. Don't do anything against them. Are you being evicted?
So even it is not their case, my lord, some proposed, they say, my lord, they are apprehending eviction, but fact remains, my lord, that fact remains that, my lord, they have been allotted with alternative plot of land. They are now not happy with those plot of
No,
land.
no, no, no. They cannot be unhappy with a plot of land being given. There's no quarrel with that. But the only question which shocks the conscience of the court is if you are allotting their lands to some other person, then it is wrong.
No, my lord, government,
You are using it for your public purpose, use it. But you can't allot it to any third parties.
third parties, therefore, my lord, on what consideration that allotment, their allegation, my lord, we have to refute it. Deputy commissioner, because it is on fact. Let the affidavit be filed, affidavit will be.
You have made that allegation?
Yes, my representation we have made. In our representation, we made it.
No, no, in your petition, you have made that allegation that that land which have been, you will be removed from or evicted is going to be settled to third parties. Mrs. S. Borua appearing on behalf of the Deputy Commissioner, Kamruk,
My lord, it is Mankasar, my lord, South Salmare
South
Mankasar.
Salmara, Mankasar, submits that she needs an accommodation for 2 weeks for the purpose of filing the affidavit by the Deputy Commissioner in respect to the three writ petitions. First, Mr. I. Chaudhary, the learned counsel appearing on behalf of the petitioner, had made a specific averment, submits that the petitioner had made specific allegations in the writ petition to the effect that though the petitioners have been allotted some other plots of land, but the plots of land wherein the petitioners are in possession, the government, the revenue officials are taking steps to allot to third parties. Taking into account the above, this court fixes this matter on 18th of September. The affidavit be filed by the respondent Deputy Commissioner. And this Deputy Commissioner, no, District Commissioner, huh? District Commissioner, South Salmara, Mankasar, by 11th of September without fail.
My lord, in one matter, my lord, WPC, my lord, that is 1,777, my lord, that pertains to, yes, this is also South Salmare.
All three are same.
I
Same.
appear on behalf of, in item number 9 and 10.
You give your name, that's all.
My name may be, don't know. My name.
Huh?
My name may be.
Why? You have not submitted anything. Should I say, yes, what's your name? What's your name?
A. Ganguly.
A. Tamuli submits that he appears for the petitioner in WP item number 8 and 9. That's all.
9 and 10.
Ito likit.
11.
This matter relates to this amount which is invested by the petitioners by his own sources, Lordship. Because this amount is expected, which is the meetup for the recruitment.
Yes, who is paying for the higher education?
Yes, so amount is 85,300.
Yes, madam. Why you are not releasing the amount?
my
He spent
lord,
from his own
Deputy
pocket.
Commissioner Office, my lord. Deputy Commissioner is supposed to release the.
Hmm?
Deputy Commissioner, my lord. This amount is kept in the DDMA account of the Deputy Commissioner. Lord.
Yes, why? He spent it from your own pocket. You hold the election, the selection,
Instruction yet. to
and
receive,
because
Lord.
of that, he had to pay from his own pocket.
Actually, Lordship, because at that time fund was not available. So as per request of the Nazarat officers, Gwalpara and principals of Pandit Dindayal Mahavidyalaya. So then he has to arrange this money by his own sources. And the recruitment process is completely smooth. Yeah, also, Lordship, till date, this amount has not been released. Lordship. So now he's facing. Here also instruction.
No instruction business in respect to
Lordship,
this type of
this is
matter.
the admitted
What is
amount,
there?
Lordship, because principal is request connected to 12
The instant writ petition has been filed by the petitioner seeking a direction upon the respondents and more particularly the respondent number 3.
Respondent number 3, yes.
Respondent number 3. For release of an amount of rupees 85,362,
Yes, sir.
which the petitioner incurred from his own pocket during the recruitment process of the assistant professor and official staff in Pandit Dindayal Upadhyay Adarsha Mahavidyalaya. The facts involved in the facts, as could be seen from the writ petition, is that the petitioner, while working as the senior assistant of the personnel branch in the office of the DC Gwalpara, on discussion with upon being instructed by the Deputy Commissioner Gwalpara and in consultation with the principal Pandit Dindayal Upadhyay Adarsha Vidyalaya, kept the recruitment fund in his office in the DDMA account as PDUMA Mahavidyalaya was a new one, and due to non-availability of bank account, the bank drafts of the examination fees was kept in DDMA account of the Deputy Commissioner's office. However, at the time when the selection proceedings were initiated, there was no fund for which, at the request of the Nazarat officer, that is the respondent number 5, and the principal Pandit, as well as at the request of the respondent number 4 and 5, the petitioner made arrangement of the money from his own source, that is an amount of rupees 85,362, and completed the recruitment process smoothly. It is also stated that after completion of the selection procedure, the Director of Higher Education Assam had issued instruction to incur the expenditure from the bank drafts as received examination fee at the time of recruitment. However, the petitioner on various occasions approached the respondent number 4, respondent number 3, for release of the said amount, and the said amount has not been released, for which the instant writ petition has been filed. It appears from the record that the notice was issued on 17/2/2021 Full stop. No affidavit has been filed by the respondent authorities. This court, upon perusal of the materials on record, more particularly Annexure B and Annexure C, is of the opinion that if the petitioner had incurred the said amount of rupees 5,362 for the purpose of holding the for the purpose of carrying out the recruitment process out of his own funds, and there being a direction from the Director of Higher Education for release of the said funds from the bankrupts received as examination fee, which were kept in the Deputy Commissioner's account, the petitioner is entitled to the said amount. This, however, would require certain verifications to be carried out at the level of the respondent number 3. Accordingly, this court therefore disposes of the instant petition with a direction to the respondent number 3 to carry out of a verification as to whether the petitioner had duly spent the said amount of rupees 85,362 for the purpose of recruitment to the post of Assistant Professor and Official Staff of PDUMA Mahavidyalaya, which was held in the month of 2017. If it is found upon verification that the petitioner had spent the said amount, the said amount be paid by the respondent number 3 from the bank account be paid by the respondent number 3. The said exercise be carried out within a period of 3 months from the date a certified copy of the instant order is served upon the respondent number 3.
Well,
The petitioner is further directed to submit all the necessary documents, which should also show that the petition before the Deputy Commissioner, Gwalpara,
Yes.
which should also show that he had incurred the said expenditure towards the holding of the said recruitment process. Yes.
Under this matter, petitioner has admitted that the alleged work, my lord, at page 17, these are over, my lord. Page 18 indicates.
In favor of the respondent. Where is that respondent number 7? What permit has been issued?
These are government permits, my lord, under Rule 5 of Assam Minor Minor Rules, my lord.
Where is the permit?
Permit is, my lord, at he had petitioner went for an ITI. Permit is, there's a information by the public information officer, page 18, 17 and 18, my
Permit is in favor of
this number 2, my lord, MB
respondent
traders.
number 7, BB traders,
Yes,
BE traders.
MB,
No, no,
B,
MB traders.
yes, it's over.
Who is MB traders? Oh, yeah.
Yes.
This period is from 7/1/2021 to 31/3/2021.
Yes,
That's it.
yeah, that's it, my lord.
The instant petition has been filed by the petitioner for setting aside and quashing the Sand Castle permit issued in favor of the respondent number 7. As well as also for a direction to the respondent authorities to stop sand trading from the said sandcastle and to conduct and for a direction that the respondent authorities to conduct a departmental inquiry in accordance with the guidelines. It transpires from the petition that the petitioner came to learn on the basis of an RTI information furnished to him that for departmental construction under the Sipsagar Forest Department, 2 sandcastles of Jachi River was permitted. One to the respondent number 7 and the other to one Abdul Ahad. The petitioner thereupon submitted various representations, and as nothing was done, for which the petitioner has approached this court, it reveals from the record that the said permit was granted to the respondent number 7 for a period from 7/1/2021 to 31/3/2021, and for an quantity of 4,300 cubic meter. Mr. D. Gogoi, the learned counsel appearing on behalf of the Forest Department, submits that the period is already over, and as such, nothing survives in the instant writ petition. Taking into account the above submission of the counsel for the Forest Department, as well as also upon perusal of Annexure 1, which shows that the period was only for the period for which the permit was given to the respondent number 7 was from 7/1/2001 to 31/3/2021. Nothing survives in the instant writ petition, for which the instant petition stands closed.
All right.
14,
Yes,
Okay, this matter relates to the allegations as regard the setting up of a cattle market illegally. They said that they are in violation of the Cattle Preservation Act and for illegal deportation and slaughtering of cattle, those are being used. But accordingly, the police has been called in, and the report of the police says that no such untoward incident or any such illegal activity has been carrying on. And it is under the pervasive control of the Dhemaji Jilla Parishad. So Dhemaji Jilla Parishad have allotted that small cattle market, and even though based on the complaint, 3 trucks have been seized finally as DGM have released it. So the allegation as brought against is totally unfounded.
Mr. S. Purwar, the learned counsel appearing on behalf of the state respondent, submits that an inquiry was conducted pursuant to the issuance of notice by this court.
No, it's not an inquiry. The police have gone and investigated, and
The
from
police, submitted that the police have duly investigated the issue involved in the instant writ petition and found that there was nothing supporting the allegations so made in the writ petition. This court is of the opinion that as that is the specific stand so taken by the respondent authorities, the same be brought on record by filing an affidavit. 2 weeks' time is granted for filing the said affidavit. List the matter again on 20/9/2023. The affidavit be filed by 15/9/2023.
15,
Yes, what is this?
Kali matter में भी बात हुआ पूरा typing lot.
Why?
K. Gogoi is supposed to appear in this matter, but he is in another court.
This is matter pertaining to what?
The tender matter.
No, what happened to this contract, madam? Nothing has happened. Now you must have awarded the contract to somebody else. Get your instructions. Who is appearing?
Hey, Google.
Ask him. One day বলে dismiss করে default তো করে ফেলে।
18,
তিনটা লোকে।
May I please your lordship?
Hmm.
Lordship, on behalf of I Hussain, my senior.
You are appearing for?
On behalf of I Hussain.
I Hussain, come here. You are the petitioner. Yes.
Lordship, the
Cannot
matter
be
is
issued
in
directing, commanding the respondent authorities to remove if the electric pole from the aforementioned plot of land. to the people. Yes, what is it?
Lordship, the matter is infrastructure.
Infrastructure.
Lordship, Lordship, the matter may be closed.
Why? Why? Tell me. Why is it infructuous? None appears for APDCL also. Tell me. How many years of practice?
Beginning.
Beginning. Fantastic. Good. We'll take it up at 3 again. Tell me why is it infructuous? Or get hold of Mr. Ayute.
Lordship, senior is engaged in court number 15.
By 3 o'clock, he will be free. Get him.
19,
My lord,
Yes.
I am appearing on behalf of the respondents. But in this case, my lord, I filed this case is for challenging the impounded data dated 18/1/2021 issued by the railway authority, respond number 4. And the tender notice 27/2021. So accordingly, my lord, they are claiming the transfer of the license, which is not tenable as per the catering policy 2010 and 2017. After the expiry of the contract agreement, their death of the original licensee, his son, being a petitioner, claiming the transfer of license, which is not tenable. So, my lord, in this case, my lord, Secretary to the Government of India, Minister of Railway was implicated in this case, for which I filed IA, my lord, for striking out the name of the Secretary to the Government of India, Minister of Railway, my lord. So, this IA number 931 of 2022. It is my humble prayer that before going into the merit of this case, my lord, this IA may be closed, disposed. So it's the direction to delete the name of the Minister of the Railway, because Minister of the Railway of the Secretary of the Government of India has nothing to do in this case, my lord. This tender notice is issued by the NFL General Manager. So General Manager in place of the Minister of the Railway, the Union of India is to be represented by the General Manager and Railway. So, my lord, Minister of Railway is not concerned in this case, my lord. He may be considered as the unnecessary party as under Order 1 Rule 9, my lord, of CPC. So, it may be, Lord, please to take out the name of the Secretary to the Government of India, Minister of Railway under Order 10(2) of the CPC. In the another some cases, my lord, already I have.
Who is appearing for the other respondents?
No, only 5 respondents there, my lord.
Who is appearing?
I am for the railway.
Tell me what is your case. I dispose it off.
Yes, my lord. This
Then-
case is, my lord, since they are
Yes.
claiming
Kindly
that
take the matter after 10 minutes. After my senior station after the case coming. After 10 minutes.
Well, this case will be automatically disposed by that, because in agreement, contact, if I go to the earlier contact agreement before expiry, there's the additional clause. And
It's the
so-
matter after 2 weeks.
Number 20,
Yes,
As per our information, Lordship, better may be picked up. So I may
this
be
is
allowed,
pertaining to,
Lordship, pertaining to the no confidence motion against the labor of the president. So. There are more time.
your name,
AK Azad, Lordship.
you're there in the case.
No, Lordship, on behalf of G.
Huh?
G Uttinon.
Why Sigdar? Why you are saying it to be infructuous?
Actually, as per our information, Lordship, no confidence motion for subsequently it was withdrawn.
Withdrawn.
Lordship, as per our
Yes,
information.
Mr. P.P. Doctor, the learned counsel appeared here for
For requisition, Your Lordship. We have requisition that no confidence.
appearing on behalf of the private respondent.
Private respondent, Lordship.
That's who had issued the notice for no confidence against the petitioner,
Lordship.
had withdrawn the notice, and as such, had withdrawn the notice of no confidence. So, as such, it is also submitted by the learned counsel appearing on behalf of the petitioner. And as such, it has been submitted at the bar that nothing survives in the instant writ petition. Accordingly, the instant writ petition stands closed as it has become infructuous.
Lordship.
21,
May I please, Lordship?
Hmm.
As per order dated 2/8/2023, last order, Lordship. This one was directed to the responding authorities to file an affidavit. Today morning, they gave us copy.
Yes, you have filed affidavit.
Yes, today we have filed the affidavit. It's not on
Mr.
record.
S. Borua appearing on behalf of the respondents submits, respondent number 2 and 3 submits that the affidavit as directed by this court by an order dated 2/8/2023 has already been filed today. List the matter again on 8th of September 2023. The registry shall bring on record the said affidavit. The petitioner, you have received the copy?
Yes.
The petitioner, counsel for the petitioner further submits that he had received the copy of the said affidavit, and the petitioner may be given the liberty to file reply if so advised. Taking into account the above, petitioner is given the liberty to file the reply. List the matter according.
Most probably.
22,
No deficit could be paid. None appears on behalf of the petitioner on call. It further appears that this court had directed the petitioner to deposit the deficit court fee. The office record note also shows that the deficit court fee has not been paid till date. List the matter again on 30/8/2023. So if the petitioner is not represented as well as no deficit court fee is paid, this court shall have no other option but to dismiss the petition for non-prosecution.
23,
Matter pertains to matter of non-payment of contractual dues. Work was executed.
Which department?
PWD.
Yes. What is your stand?
Lordship, I have not received any instruction.
Okay, you make a verification
Yes, sir.
and then pay 6 months.
Applied.
1 month verification, then pay as per Tafsir Ali.
I'll-
Give your names, huh?
four and 25.
Materials supplied for committee and Rega, my lord. The respondent filed an affidavit and admitted the amount. Respondent,
All these.
24.
It's a matter.
In 24, they submitted the affidavit, but in 25, no affidavit.
Why are two matters different
Different supplier. They are different.
cases? Why are they taken up together?
I think the real number is
Oh, same, so nearby.
nearby.
And you are the same lawyer?
I am for both the items.
You are the same lawyer?
Yeah.
So for your convenience, we have to both the matters together.
But my lord, in 25, no affidavit filed, my lord. 24, affidavit,
NREGA, who is going to pay?
my lord, the,
PNRD?
yes, my lord.
Okay. How much amount?
76 lakh, my lord.
Huh?
18,000, 76 lakh, 18,000.
My goodness.
804.
And they have admitted?
Yes, my lord.
Who has admitted?
Paragraph 12 of their affidavit. Paragraph 12 of the affidavit.
Who is to pay? The deputy commissioner
Yes.
or the revenue?
No, my lord. The deputy
Huh? Who pays this amount?
commissioner.
Yes. Who pays this amount?
My lord.
Deputy commissioner. You are the deputy commissioner come district program coordinator.
Yes.
Lordship, can I be given an opportunity of going to the affidavit? I don't have it.
It is admitted, my lord. Paragraph 12. my lord.
Okay, have a look at it. Take my file. Look it. We'll have it at 3.
Public.
Give him the affidavit which he has filed. Who has filed?
PTO,
Then
26,
Lordship, it is the Panchayat, PNRD. They have to be here.
PNRD will get all the PNRD. Mr. Kadir, you wait or get hold of a PNRD council. Yes, madam, what is this?
Lordship, appearing on request of Mr. R. B. Nath, Lordship, the engaged counsel is not feeling well.
Relieved by the order passed by the State Police Accountability Commission in complaint case number 12, acquitting the respondent from the petitioner has prepared this.
Lordship, the engaged counsel is not feeling well, Lordship. He is suffering from fever. Kindly matter be taken up on Monday.
At the request of the learned counsel for the petitioner, matter stands adjourned for 4 weeks.
Okay.
27,
Wait, please. Construction was not for, because our contract was terminated.
What is the instruction?
Lordship, I have received it.
Work completed.
Lordship, hardly 5%. Lordship, there.
And what have you done with him, the petitioner?
Well, at page 18 is the IP note, 1A. There is a clause that imposition of 20% penalty on the value of the work not completed.
Termination of the contract for work of so and so. Now I so and so in the so and so. Then, what is wrong with this order?
Because your lordship may turn to page 16.
No, you were supposed to complete your work by 31/3/2020.
Thereafter, because of
COVID, there was no COVID.
there was some other problems in the site.
So why your entire petition is on the basis of COVID?
And my lord, and page
Did
17
COVID
of-
come before that?
my lord,
Your
page-
Sam,
Page 17, I made a statement that within November 21st, I would have completed the work.
no. Why can you, how can you complete it? It's a road work. You have to complete it by 31/3/2020.
At this moment, if your lordship can consider that 20% penalty may not be imposed.
Why?
My lord, because your lordship may consider.
No. There's no case out here. 20%, that is a contractual term. You want to file something, go ahead, do one, whatever may be. That is a different thing. This court cannot do that. Why the 20? That is a contractual term if you fail to do so. The agreement says, yes, which clause is that, Mr.?
My lord, clause
So
that-
many notices were issued to you. Can't give the construction of a road. Yes. Where is the contract?
Here, what I find from this condition of contract. This relates to my lord smart city, but I don't find that particular real condition of contract. For PWD work is there one real condition of contract.
Now, how did you approach this court with 20% imposition?
Because
What is wrong? Isn't that a contractual term? What is there?
the only thing during that period, they have not given the time when I approached this court, they have not given the work body.
Better withdraw. If I hold it, then it is right.
Your lordship may give-
20%, then you are in more trouble.
my lord, your lordship may, because my some amount yet to be paid to me.
No, the entire amount has been paid to you, 2,90,000, you have got it. Value of the work, up to date payment made to Sri Buragoi, 2,90,000, 2 crores 90 lakhs, 8,727. Physical progress of the work done by Mr. So-and-so is 72.34. Date of termination on 8/7/2021.
21.
Then, what to do? Dismiss. If I dismiss it, your matter becomes more worse for you.
My lord, your lordship may give me a liberty that I approach the civil court for any other conflict. My lord, that much.
The learned counsel for the petitioner submits that taking into account that the work has already been allotted to one Mr. Guljar Hussain, on taking into account that the remaining work has already been allotted to one Guljar Hussain, on the basis of an agreement dated on the basis of an agreement on the basis of a letter of acceptance dated 1/2/2022. The prayer made in the relief sought for in the writ petition relating to a writ in the nature of mandamus, thereby directing the respondent authorities to permit the petitioner to complete the remaining work, does not survive. The Learned Counsel further submits that the imposition of 20% of the 20% on the remaining work, on the value of the remaining work upon the petitioner is bad in law for varied circumstances which have not been taken into consideration by the respondent authorities. The Learned Counsel further fairly submits that such varied circumstances to adjudicate the such circumstances, it would entail adjudication on the facts for which the Learned Counsel submits that the petitioner may be given the liberty to approach the appropriate forum wherein disputed questions or facts can be adjudicated upon. Taking into account the above submissions, this court closes the instant writ petition. However, liberty is given to the petitioner to approach the appropriate forum only insofar as the imposition of 20% of the penalty, 20% penalty on the incomplete work by the impugned order dated 8/7/2021. The instructions are produced by Mr. B. Chaudhary, the Learned Counsel, appearing on behalf of the respondent PWD, is kept on record and marked with the letter X. It is further observed that the observations made herein shall not prejudice the petitioner in any such proceedings so initiated by the petitioner. It's permissible under law. Oh, this name I,
Maybe the lordship,
28.
humble request.
Tell me, this is a matter which have been heard. You are giving it to him who stays in Calcutta. Why? You got a record to me. This case has been fixed by informing Mr. Sikdar the date.
Lordship, may I submit? Lordship, day for yesterday, Mr. Sikdar was before your lordship to mention a matter that he won't be available today. So unfortunately, he is not available. Lordship may take up the matter tomorrow. He'll be available tomorrow to your lordship.
Let me, I'll take up the matter. Tomorrow is for final. Yeah. Yes. Why have you given it to him? That is the only question. A person who resides there, you have not given. You given somebody to some person who is in Calcutta. Why?
Formal application has been received by the authority lordship. Formal application has been received by the authority lordship.
So you did not submit any application?
Question does not arise. I do not know, my lord.
Oh,
I have no knowledge about it. Like after this impugn order, my lord, I came to know that this matter was given. The land was given in favor of the.
you were staying in government land.
Yes, it is half government land. Government land.
You were staying in government land.
Yes.
And she was never staying there,
She is residing in Calcutta. my lord.
Calcutta, and after her marriage.
After her marriage.
And she made an application, so
Yes.
she got it.
Yes, she got it.
And you are residing there, you did not get it.
I did not get it and I did not apply because it is a government land. It was not necessary on my part to approach the authority since from the last, my predecessor, I have been using this land.
No, no, no. You have to approach. Don't you think so?
But if circumstances is compelled, I am ready to. If I know that the government is giving, then I will apply, no doubt. But it is a family land, my lord. It is a joint family land.
It's a government land.
Family government land, but it is using by both the parties. Respondent number 5, father and the deed petitioner, my lord.
Hmm.
The dispute is within the family member.
Hmm?
The dispute is within the family member.
Then why you are not filing a civil suit?
My lord, it is the bar under the Assam Land Revenue Regulation.
What is the bar?
No civil suit can be filed.
For what?
Government land, my.
Is it?
Yes.
Where is it?
Well, it's like 80 something.
Show me that. For so many years of practice, I have never seen that provision. 154 you are referring to?
Yes, perhaps. Yes.
Can the regulation say that the civil suit, that the only 154 says as regards the bar of civil suit in respect to those circumstances which is mentioned, mutation? As regards record of rights, 154C,
Yes.
then?
Yes.
Why you are not filing a civil suit?
My lord, 154 matters exempted from cognizance of civil code.
Ah.
Yes.
Yes, tell me where.
Except when otherwise expressly provided in this regulation or in rules issued under this regulation, no civil suit shall exercise jurisdiction in any of the following.
Which are, where do you fall in?
As to the validity of the effect of a settlement, as to whether the condition of any settlement are still in force. A question as to the amount of revenue tax or trade be assessed and the modes of principle of assessment. The formation of the record of rights or the preparation of signing or alternation of any document contained therein. Claims of person to perfect partition, claims of person to imperfect partition. My lord, there are so many other there. My petition is under section 163 of the land regulation, my lord.
What is that?
163 is, my lord,
Tribal land?
yes, tribal land, my lord. Disposal of land for the purpose of cultivation, my lord. In the disposal of land in areas to which the provision of this chapter apply for this purpose of ordinary cultivation or purpose ancillary, that shall be in accordance with such policy and procedure as may be adopted and directed by the state government.
Absolutely no. That is chapter 10.
Yes, my lord.
Now, chapter 10, here is a case where you have a problem in granting the settlement in favor of the respondent number 5.
Yes.
You say that the land should have been settled amongst everybody,
My lord,
or not at all.
my lord, if as per the law clause 2A, my lord, if the government land is, if government is interested to allot the land for the purpose of the public interest, the petitioner has nothing to do, my lord. Since the petitioner is also a member of the family, but respondent number 5.
But why haven't you applied?
No such scope was available by that point of time, my lord.
Oh,
No such scope was available.
what is this no such?
Because the petitioner did not apply for settlement of the land. The settlement of the land was applied by respondent number 5. And respondent number 5.
Obviously, she is more clever and has applied. You must be sitting out there, not doing anything out there. That must have been the reason why.
But as per law, my lord, unless public interest is involved, the settlement cannot be given.
Okay, Mr. Talukdar, just tell me how to settle this issue. Tell me, what do you want? You want the settlement to be set aside?
My prayer is settlement should be, because it is not for the public interest, it is for individual interest. If it is public interest, I have no objection, my lord. This is
No,
even,
can't a person
Yes.
claim settlement over the land?
when the petitioner is in possession of the land, how?
So what?
Without.
No,
getting-
whatever may be.
My lord,
What right do you have to remain in possession of government land?
maybe, but the respondent authority should give an notice to me at least.
Why?
Should inform, should.
Not
because I am
necessary. You are a trespasser.
Not a trespasser, my lord.
Yes, tell me, what is
From
your
60 years I am using, my lord.
You'll be there for 100 years.
Yes.
Do you have any right over that?
My lord, I may not have right, but I have a possessory right.
What right?
Possessory right. Possession, I am in possession. If the person
Possession
wants-
right?
Possessory right, my lord. Yes, and
Now see rule 16 of the Assam Land and Revenue Regulation.
yes, my lord.
Open it, rule 6 settlement rules. Let's see. What possessory right you have? Your submissions, I think, this land and revenue regulation needs to be amended. I hope you got the rule. Rules, the rules of settlement rules.
Yes, my lord.
Yes. What right do you have? Yes, read it.
The deputy commissioner, my lord. Land Development Regulation Rule.
1616.
Yes, my lord. 1/6, right of his deputy commissioner with previous,
Yes, yes.
the deputy commissioner with the previous sanction of the state government may proclamation published in a prescribed manner, declare any collection of water running or still or to be fishery and no right in any.
No. You are reading something. You are reading the regulation. I'm saying about the rules.
Yes, my lord, yes.
Mr. I. Talukdar,
Yes.
you go through the settlement rules and then tomorrow at 2 o'clock,
Yes.
we finish up this matter.
Right.
Okay?
Yes.
Fantastic. She's also holding into the record something needs to be done.
Yes.
The best option is, think about it. The only way out to save your grace in front of your client is that you submit also an application and I direct the deputy commissioner to decide as to who should get it. That is the only way up. Nothing more.
Deep level.
This is the matter tomorrow at 2 o'clock. And go through Rule 16. You have no right.
Twenty-nine.
Yes, Mr. Sharma, nobody appears against you, something?
Yes, my lord, we have already complied with the interim order and we have already given electricity connection to the petitioner. We prefer. Even on the last occasion, 11/5/2022, none appeared for the petitioner. Madam.
You have given the connection.
Yes, ma'am.
The learned counsel appearing on behalf of the instant writ petition has been filed by the petitioner that seeking a direction upon the respondent authorities to restore back the electricity connection of the two shop premises belonging to the writ petitioner. And also to direct the respondent authorities to provide separate electricity connection of the two shop premises. The learned counsel appearing on behalf of Mr. S. Sharma, the learned SP Sharma, the learned counsel appearing on behalf of the APDCL had submitted that that pursuant to the order dated 11/10/2021, the electricity connection to the petitioners, 2 shops have been restored. Taking into account the above, the grievance of the petitioner has been duly addressed. Nothing survives in the instant writ petition for which the same stands closed. Anyway, there is one judgment, no? Recent
Yes,
judgment
my
of Justice. Hima Kohli?
No, my lord.
Recent judgment, very recent judgment.
Yes, my lord.
Indra, no, Indra,
Indra-
Judge
Indra-
Indra
Indra
Banerjee.
Indra
Indra Banerjee.
Delete death through.
Huh?
It's a delete death through versus something.
Delete that.
Yeah,
Yes,
criminal appeal,
yes.
my lord.
Where it has said that the landlord's
Yes,
no
sir,
objection has
is
no
not
value.
required. He was given enough opportunity.
Now you have already allotted the work to somebody else.
Yes, because there is an observation, lordship. Because workers call to lordship. Yes, because there is observation outcome the repeating, so we are not proceeding. There is an observation of the honorable court. The initial date.
Same shall be covered by the outcome of the
outcome
repetition. Then
So that's why lordship, the department of all proceeding.
there is work to be completed.
Work is not completed, lordship.
So you can go ahead with it.
Lordship.
We'll do one thing.
Urgency is there because lordship is a lordship strategic position. I think Tezpur Airport lordship.
Show me your affidavit, what you.
Affidavit, lordship, in our affidavit, paragraph 3, we have stated, lordship. Paragraph 3, my lord may kindly come to internal page 3, lordship.
Internal page.
3 of paragraph.
Yes.
Running page, I am not. 2, lordship.
The work for provision of furniture for fence.
And next page is the lordship reminder. Total 13 reminder is given to him, lordship.
We dispose it of.
Lordship.
That unnecessarily these matters not
Lordship.
remain.
Lordship.
He has not supplied a single.
Lordship. Yes, not. Lordship, page 31.
Petitioner herein have filed the instant writ petition challenging the seeking a direction that the respondent should not cancel the contract in terms with in exercise of the powers vested under condition 28 of IAFW Gap 1815Z and to allow the petitioner to complete the work within a fixed period. It reveals from the records that the respondent number 3 had entered into a contract agreement number CWE bracket AF bracket close oblique TEZ 2018/10 of 2018-19 with the petitioner by letter number 83810/14/E8 dated 12/6/2018. On the basis thereof, the work order number 1 was placed on the petitioner by the respondent number 5 by the letter dated 10/7/2018 for the time for completion of the entire supply within 7 months from the issuance of the work order. The petitioner duly accepted the said work order. It is also seen that the date of the period of completion of the work so accepted by the petitioner was for the period from 13th of July 2018 to 12th of February 2019. However, the petitioner did not supply any of the articles for 28 months from the date of commencement of the work order. Under such circumstances, notices were issued on 23/1/2019, 29/1/2019, 13/2/2019, 7/3/2019, 14/5/2019, 30/5/2019, 13/8/2019, 21/3/2020, 23/5/2020, and 37/2020 and 10/12/2020. However, even after the issuance of the said notice and a lapse of more than 31 months, the petitioner failed to supply any article of furniture. Under such circumstances, by an order dated 16/2/2021, the contract was terminated. It further reveals that the writ petition was filed on 19/7/2021, seeking a direction that the contract should not be terminated and the petitioner be allowed to perform the contract, be allowed to complete the work within a fixed period. Taking into account the facts enumerated herein above, as well as also that the contract was already terminated prior to filing of the writ petition, this court is of the opinion that this is not a fit case for exercise of jurisdiction under Article 2 to 6 of the Constitution. Accordingly, the writ petition stands dismissed. Interim orders, if any, stands before.
Time being item 18.
Yes.
I had prayed in this writ petition for shifting of the electric poles and the high tension line that was over my land. Subsequently, your lordship, after filing of this writ petition, your lordship, my grievance has been addressed by the respondent, your lordship.
The instant writ petition was filed by the petitioner seeking a direction that the respondent authorities should shift the electrical poles from the land belonging to the petitioner and or to direct the respondent authorities to pay adequate compensation to the petitioner. The learned counsel for the petitioner duly submits that pursuant to the filing of the writ petition and issuance of this notice, the poles, electrical poles have been removed from the petitioner's land, and as such, nothing survives in the instant writ petition. Accordingly, the writ petition stands closed.
Timing item 24/25.
Yes, PNRD.
Well, in the first case, the affidavit isn't filed. In the other one, the affidavit is yet to be filed. It is for vetting matter.
Is he entitled to the money?
Yes, ma'am.
Who is going to pay?
It is the BDO who actually stated that it's entitlement. Actually, we should pay him.
PTO, my lord, by electronic fund transfer method, he transferred the fund directly to the account of the vendor, my lord, the PTO method. After verifying and approval of the, after verifying the and approval of the bills, my lord. So since the BDO admitted the amount, my lord,
BDO admitted the
Yes.
amount.
he filed the affidavit.
And
The commissioner may be directed by the PNRD. Subsequently,
Commissioner PNRD will pay.
he will direct the BTO, or the BTO may be directed, my lord, for payment. Because the process is that, my lord, there is no requirement for any sanction by the commissioner, my lord. After verifying the bills, my lord, is the first signature is given by the accountant, my lord, and second signature is the BTO, my lord. So as soon as the BTO put his signature, the amount is directly credited to the account of the vendor. This is the process.
This is supply as regards NREGA.
MG and Rega material. So, my BTO can.
Yes, Mr. Devnath. Who is going to pay?
The BDO will be directed to the needful matter.
Hmm?
To the needful matter. BDO will be directed. Because it's the BDO who states manner that the petitioner is entitled to this amount and say there's an outstanding of 7 lakh. 76
BDO
lakh.
has stated.
Yes, ma'am.
In one case, affidavit has been filed.
In the
Other case,
yet to be filed, it is sent for vetting matter.
but you have the instruction.
Yes, ma'am.
Give me the instruction. Why the payment has not been made?
The reason
Huh?
has not been given, manner in the instruction. Reason has not been given.
You are taking his services. Why we did not impose interest on him?
Period of 1617 and 1718, my lord. The year period of 1617 and 1718. Say about 5 years. The material supplied 5 years. Pending seal. They have a prayer also, my lord, for the interest.
Interest to pay, night.
देखो कहता हूँ मैं कोई कुछ भी तो अपनी The instant writ petition has been filed by the petitioner seeking a direction upon the respondent number 6 and 7 to release the amount of rupees 76 lakhs 18,804 for the materials supplied by the petitioner for different schemes under the MREGA MGNREGA within a stipulated time with interest. It reveals from the it appears from the writ petition the petitioner, that a junior engineer what?
PNRT, my lord.
Huh?
PNRT department. PNRT department.
PNRD department had requested the petitioner, who is a registered supplier under the DRDA, to supply materials for the various schemes as mentioned in clause Roman 1 to Roman 21 for the of paragraph 6. For the financial year 2016-17 and 2017-18. The petitioner accordingly supplied the materials for the work site at the work site of the respective schemes, and the concerned junior engineer, having received the same in full and in good conditions, made entry in the measurement books. The said junior engineer thereupon submitted the bills along with measurement book in the office of the Borkhala Development Block. The block development officer thereupon after making necessary verification, passed approved the bills with a direction to his officials to do the needful for payment. The petitioner submits that as per the verification so made by the block development officer, the petitioner is entitled to an amount of rupees 76,18,804 for supply of the materials by the petitioner. The petitioner thereupon has approached the respondent authorities for making payment of the said amount. However, no payment has been made, for which the petitioner has approached this court under Article 226 of the Constitution. This court had issued notice on 13/9/2021. It reveals from the records that an affidavit in opposition was filed by the respondent number 7, wherein it has been stated that the block development officer, Borkhala Development Block, duly admits that the petitioner is entitled to an amount of rupees 76,18,804 for the year 2016-17 and 2017-18. Mr. N.K. Devnath, the learned counsel appearing on behalf of the PNRD department, has produced an instruction issued by the Chief Executive Officer, Qatar Jila Parishad, Silchar, wherein which contains the parawise comments under the signature of the Chief Executive Officer, Qatar Jila Parishad, Silchar. In the said parawise comments, it has been admitted by the block development officer, Borkhala Development Block, that an amount of rupees 14,90,160 is outstanding and payable to the petitioner for the year 2014, 15 and 15, 16. The above stand taken by the respondent shows that the block development officer had duly admitted the dues of the petitioner. This court further taking into account Mr. Devnath, it is only the block development officer who will verify and say, and matter will be over. Shouldn't I direct the commissioner and secretary to have a verification? I think that is better. The huge amount. Mr. N.K. Devnath further submitted is duly admitted. Be that as it may, Mr. N.K. Devnath duly submitted. The learned counsel for the PNRD duly submitted. That the said admission of the petitioner's entitlement is made only by the block development officer. He submits that the commissioner, I think commissioner will do. The commissioner, Panchayat and Rural Development Department may be further permitted, may be directed to carry out a verification as to the entitlement of the petitioner within a time frame. Taking into account the above submission and the categorical admission of the block development officer, this court disposes of the instant writ petition with a direction to the Commissioner PNRD to carry out a verification as to whether the petitioner is entitled to the amount of rupees 76 lakhs so and so. And upon making necessary verification, if it is found that the petitioner is entitled to, the said amount be paid to the petitioner. The said exercise be completed within a period of 4 months from the date a certified copy of the instant order is submitted to the commissioner of PNRD department.
By the petition. Certified copies submitted by the petition.
Shorter time, long pending, my lord, shorter period. 3 months.
Mr. Kade, first of all, this petition, otherwise, if other courts were not doing, if I was the first person to take up this petition, I'd have dismissed it on the ground of limitation. 2016-17 matters we are doing in 2023. Non-payment of take it back. Not dedicated.
30.
Yes, Mr. Roy. What is there?
Yes, notice against rule 18(3)(a).
Huh? Impugn notice should not be set aside. What is this notice business? 29 here. It is under you have occupied government land of so and so. Vacate, failing which action will be taken as per law. What is there wrong with that? You are in government land.
No, here, Lord, please to peruse the date of the notice. It is dated 29. And eviction was done on third day.
You have been evicted.
No, others have been evicted, petitioners have not. Some other persons have been evicted.
Now what are you showing?
I was showing lordship, please come to page 15.
Page
15, annexure 3.
15. Yes.
This is the notice dated 29/10/21 issued by the circle officer lordship.
Hmm.
Here he has mentioned inform you that you occupied the government land of tag number 184 of village so and so, and as such the notice under 83 is given to vacate the said land, failing which action will be taken as per law. But eviction lordship that was done on third day. Whereas lordship rule 18(3)(a) provides for giving 15 days notice. The circle-
Inform that you are occupied so and so and is given to vacate the land, failing which action will be taken. So
Lordship,
you say that another 15 days should be given, mentioned out there.
no lordship, before expiry of 15 days, a person cannot be evicted. A
But what do you say? Action will be taken as per law.
Lordship,
As per law will understand it to be 15 days.
but he started eviction on third.
Has he evicted you?
No, the present petitioner had not
We are
been.
not
evicted.
concerned with others.
No,
No, are we concerned with others?
lordship, the
Yeah, Mr. Roy, if you are saying that it is a public interest litigation, we'll take it. That's the difference. But otherwise, tell me why it is. And you want the 15 days to be mentioned. Yes,
lordship,
Mr. Goswami, put the 15 days. Matter over.
no.
You want that?
I am having other point. It is one of the point.
One of your ground. That ground is gone. Then next,
The next is lordship, the petitioner's predecessor interest, they are in possession of the land. Land area is lordship 2 lesser, 3 lesser, 10 lesser, this is the lot. And they are in occupation of the land lordship with more than 40.
then
More than having the whole house number, holding number lordship. Just one document your lordship may please to peruse. The father of the petitioner number 1, his holding was registered page 12 lordship annexure 1 in 2006. Which stands in the name of Mahadev Prasad Lothi, who was the father of the petitioner. Similarly, lordship, other petitioners, they are also having hold and they have been positioned through their petition since last 40 years. Lordship. And regarding the area of land lordship, I have described in my petition, which shows that
oh, Mr. Roy, you have been thrown out on 1/11/2021.
no, that is not
And
correct.
you obtained an interim order on 12/11/2021.
No, lordship. What happened, lordship? Large number of persons were
We
occupied.
dispose of the repetition, maintaining
Lordship, please.
status quo.
No, my case is
Status
different.
quo,
Lord.
sign that.
The other petitioners were evicted. But due to
Lordship, they-
It has
encroach
been
the land.
mentioned that all the encroachers along with the petitioners were evicted from their respective encroachment and the entire land was free from encroachment.
Thereafter, the circle
So,
officer.
so the thing is, if you have not been there, you are still there. So no problem.
Yes, paragraph 5 of our affidavit law. They
Very
again
well,
encroach
Lordship, the circle officer has filed the affidavit stating therein that after
Again.
eviction, we have again occupied.
Where is it?
paragraph
Yes.
5 law.
Yes, that is, now no area of land, nothing has been
That's the
mentioned.
petitioner number 1 has again illegally encroached portion of the land. Oh, you were evicted and again you came back.
No, lordship, these all other persons were evicted, but due to, because after 5 PM lordship, the eviction was stopped.
Hmm.
And our houses were not demolished. The present petitioners were not demolished.
Hmm.
But the circle officer in the affidavit in opposition lordship
have stated that present petitioners were also evicted, but again they have reoccupied.
Mm.
So Lordship, when the order 13 rule 3A provide that 15 days notice could be given, Lord, is mandatory law. And their notices were given on 29th Lordship, and third day the eviction proceeding was started. This is admitted position. Circle officer himself have stated that all the persons were evicted on 1/11/21 Lordship. How that power can be exercised under order 18(3)A Lordship? Absolutely without.
Okay, then we do one thing. We set aside the notice.
Yeah.
As you give them the power to exercise under 18(2).
18(2) cannot be exercised. This is
Why?
not a roadside land.
Why? Where is it? Show me.
18(2)
No,
can be
no,
applied
miss-
only about roadside land.
Show me that. Show me. Read it.
Yeah.
No, let us read it, Mr. Roy.
Yeah.
Show me. Where is roadside land? 18(2).
It says that subject is herein after provided the deputy commissioner may eject any person from land over which no person has acquired the right of a proprietor landowner or settlement when such person when such person enter into possession of the government fast land, vast land or estate over which no person has acquired the right of proprietor landowner or settlement or any land as previously been reserved road or roadside land.
Understood all.
Yes.
Everything. If you don't have a right also.
No, I have a right, Lordship, because
right?
as per section 27 of the limitation, as because I have been in possession since last more than 40 years.
27 of what? Then file a suit. Limitation Act doesn't apply actually. 27 is different. 27 is that has the
Extinguishment of
different
the
connotations,
right
and there
of-
is, and in fact, if you see the recent judgment of the Supreme Court on adverse possession, it says
Yes,
that there cannot be an adverse possession against the government.
Ravindran Kaur, Lordship, Ravindran Kaur has let down the law.
But it shall not apply against the government.
So why it will not apply?
It won't. That is what is
Yes,
the
yes.
judgment.
Lordship, adverse position, in case of a private person, limitation is 12 years. In case of the government, its limitation is 30 years. That is the only difference.
So
Why it
prove
will not
it.
apply?
Prove it before the civil court if it is so.
That's why, Lordship, it may be remanded back to the DC and I'll file my grievance. I'll submit my reply, Lordship. That's what
No, nothing to it.
that power under settlement rules, Lordship, order 82(3).
Mr. Roy, Rule 18(2), if you are so, what do you call, you want to challenge, do something, challenge Rule 18(2). As you have been under the impression, I was also initially, I didn't look into that. Rule 18(2) earlier was only reserved for grazing lands, roadside, as well as also another land. There were three
Thereafter,
lands.
there was a,
This 97 amendment was made.
Yes.
And thereby anything has been given. Any wasteland you can't be there. And this is the exercise of powers.
Lordship, please to consider, there is a difference between rule 18(2) and 18(3)A, Lord. In a rule 18(2), Lordship, even 1 day time cannot be given.
So that is why I'm saying, let me set aside that. And then allow them to take due action as per
No, no,
law.
I may be given an opportunity to file my objection.
Why should you?
So forth.
Why should I? I'm setting aside this document. You can't do it without, as per this. However, liberty is given to them to take action as per law.
Okay, Lordship, that can be done. I will file a title to claiming at first.
That you do. The instant writ petition has been filed by 3 petitioners, or 5 petitioners, challenging the notice dated 29/10/2021, primarily on the ground that the said notice was issued under Rule 18(3) of the Settlement Rules framed under the Assam Land and Revenue Regulations 1886. However, the mandatory 15 days period was not mentioned in the said notice. Continue. Land and Revenue.
I may be allowed to state about a High Court division bench
Which
that
one?
Dhan City
Which one?
Petrochemical Limited case,
When?
where it is our High Court held that Stockers notice must be given.
Huh?
Stockers notice must be. There are two cases.
No, that I'm writing it. Don't worry.
Lordship citation is Lordship 2018.
This court have duly taken note of the provisions of Rule 18(3)(a), which stipulates that in all other cases where ejectment shall be preceded by, in all other cases, the ejectment shall be preceded by a publication of notice in the manner prescribed, requiring the occupant generally to vacate the land specified in the notice within 15 days from the date of publication of the notice on the land concerned or in a prominent place in the vicinity thereof, and to remove any building, houses, fences, or crops, etc., which may have been raised on such land, semicolon, provided that the Deputy Commissioner may give time to any particular occupant to harvest the crops, if any, growing on such land, full stop. The mandate of Rule 18(3)(a), therefore, is clear that there has to be a notice thereby enabling the occupant to vacate the land specified in the notice within 15 days. It is also seen. Now coming to the notice dated 29/10/2021, so issued to the petitioner. There is not though mentioned in the said notice that the petitioners have been granted 15 days time to vacate. Further to that, the notice, in the notice, the occupied area of the land have not been mentioned by the petitioners.
I have mentioned.
It is not mentioned in the notice. Where is it?
In the notice, it is not.
So that is what I am saying.
In my petition, I have it.
Not concerned with that.
2 lakh certificate.
Have not been mentioned, which is also a requisite of a valid notice. Be that as it may, it is also relevant to take note of the affidavit in opposition filed by the Circle Officer, Guwahati Revenue Circle, wherein it has been mentioned that pursuant to the notice dated 29/10/2021 issued, an eviction drive was conducted whereby the encroachers of dark number 184 were evicted, including the petitioners. And 234.04 R of land was freed from encroachment. It is also seen from the said affidavit that there is an allegation that the petitioners thereupon again encroached upon the land. Taking into account the above, and more particularly, the mandate of Rule 18(3)(a) of the settlement rules, which categorically mandate that 15 days time ought to have been granted, is required to be granted to the occupant to vacate this land. In their occupation. And also the said notice being completely ambiguous in respect to the portion of land which the petitioners are the occupants were possessing. This court has no other option but to set aside and quash the notice dated 29/10/2021. Accordingly, the instant writ petition stands allowed. Mr. You are the circle officer? Mr. N. Goswami, the learned counsel for the petitioner, submits that the setting aside and quashing of the notice issued to the petitioner should not preclude the respondents to take such action as permissible under law. This court makes it clear that this court has only taken into consideration that the notice dated 29/10/2021 issued to the petitioners was not in accordance with law on account of the infraction to Rule 18(3)(a) and the ambiguity in the notice as regards the land occupied by the petitioner. The above observations so made and the setting aside of the notice dated 29/10/2021 shall not preclude the respondent authority to take such steps as permissible under law.
Public.
31.
My lord, I am having it 38 here. That matter will take long time.
No matters take long time. We are coming now. Wait 5 minutes. Yes, who is appearing here?
This matter pertains to delimitation of the Tiwa Autonomous Council constituency. Their lordship will kindly peruse the last order. They had assured this honorable court that they will file their affidavit. And even today, the affidavits have not come.
My lord,
Last order is 21st of July, 2023.
my lord, I received this instructions yesterday only, my lord.
So my lord, this is the instructions, my lord. I
So
received it.
your instructing person, that is the secretary to the government of Assam, Department of Tribal Affairs also wants that you should act fast. He gave you this letter saying that you are to file the affidavit by 23/8.
Well.
So
My lord,
he did not consider about your plight.
Madam.
What to do?
my lord,
So the instruction is clear that you are to file your affidavit by 23/8.
my lord will permit me 2 days time, my lord. I will file the affidavit. my lord. I just received the instructions yesterday only, my lord.
That is what I am saying.
My lord,
He says that you are to file your affidavit by 23/8.
I received it
Yesterday.
22nd, my lord.
Huh?
Yes, my secretary is clear, my lord, but it is,
They also now Assam is the government of Assam is moving very fast,
my lord,
and this should be a good example for everybody.
my lord, you will,
This is the manner in which the Assam government is functioning. So
Madam-
next time when somebody asks for affidavit for 2 weeks, I will show this letter.
my lord, you will see the thing.
But to give this instruction, they have taken 2 years. That they have
My,
not
my,
mentioned.
my lord, you will find a thing. She has signed the letter in the morning 1:38. That very odd hours she was working, my lord, for this instruction.
Oh yes. Okay. This is a matter pertaining to it. The Respond number 1 and 2 has filed. You are appearing for respond number?
No one has filed one so far.
No, 1 and 2 has filed.
Okay.
1 and 2 has filed.
We filed it.
1 and 2 has filed that I am the joint secretary of WPC and BC
Yes, my
department.
lord, they have filed. This is for the, actually, my lord,
They are the main thing that has not even been addressed. There was a committee constituted. What the committee has done, that is yet to be put on record.
Anyway, the Mr. Ardhor, the Learning Council, appearing on behalf of the Department of Tribal Affairs, submits that he requires an accommodation of 2 days,
my lord, I will do.
7 days for filing an affidavit, filing the affidavit, as he had received the instructions only yesterday. So taking into account, list the matter again on 11th of September 2023.
11, I mean, can it be any other date? Can it be 13th?
Okay, 13th of September 2023. The affidavit be filed by 7th of September.
My lord, I,
Right.
August is full. I've been instructed not to give any dates on August. 32. You want it to? Yes. What is this long order? What is there? What is this matter?
Allotment of DTR land for, they are claiming, they are holding a DTR block of land and they are claiming for allotment. And that is, there is one round of litigation already done. This honorable court has directed to consider the application. But it's a DTR land. And
So visual land can't be given
no,
to them.
we cannot take.
The only thing that they have to move an appropriate application
No,
for other lands.
Yes. But for
That order
something-
which I have passed in that matter, na, today that matter is there. I think it is a matter MSC. I gave him the permission to list the matter today, na, for some correction, where his name wanted to insert. I think it will come up in the supplementary list. Ane? Supplementary list. Huh? No supply. Oh. Okay, anyways, none appears on behalf of the petitioner on call. List the matter after 4 weeks. You have filed your affidavit. In the meantime, the revenue as well as the office of the deputy commissioner shall file the affidavit. If so, it shall file their 33. Yes.
Happy the Lordship.
Hmm.
In this matter, the respondent number 2 was an advertisement for allotment of retail outlet dealership.
Hmm.
Under various categories, my lord. I applied under the category of women, my lord. My application was taken, then interview was conducted. I scored the highest mark. Even after that, my lord, they have not come forward to issue any retail outlet dealership in my name.
You filed affidavit. Why you have not given?
The site evaluation committee's remarks, my lord, come to my affidavit page 7,
Page?
giving the running page.
And you should get your running pages in order. Nowadays it's very difficult. Page 7, yes. Show me. Evaluation of the site selection committee.
Yes,
Yes. How much did the petitioner get?
my lord,
Vitali Kolita.
he is the selected one, my lord. The remarks, my lord.
I scored the highest mark.
You are the selected.
Yes, my lord. I scored the highest mark as per the selection list.
The interview for retail outlets, an interview is held, and based on the norm, marks are given. She was the highest mark holder. She was selected. Then the site evaluation committee carried out the site inspection.
Where?
Then the inspection.
Yes. What is wrong?
The remarks, my lord, come to page 7 at the very bottom.
3-meter wide
3-meter wide
earthen track is located at a distance of 150 meter from the nearest edge of the plot towards Dundoni on Swen. This is in violation of the new revised MOT guidelines stated demand, which will render the plot not suitable for development as detailed. Clarification for the above may be obtained from the higher authority. Upper plot has scored more than 75 marks. Now, what has happened there?
No, my lord, the second part, they say that it has the sale potential of 75%, and the higher authority might take a decision. And till date, whatever I stated in the affidavit, as per my inspection, no decision has been taken. Perhaps this my learned friend agrees. The matter can be remanded to the IOCL for the higher authorities to decide on the comments given by this 3-member committee.
Why should it be after 2021 this has happened? This is a report of 2013.
12, the advertisement was published.
No, this is of
But
2013.
still, it's lying dormant, my lord. No, it has not been given to anyone.
Then why is that? Why they are not taking any decision? The higher authority.
That part has been, the respect has not. Sale potential is there. Sale potential is there. The site is in the national highway. And the moment it comes in the national highway, a lot of guidelines come to play by the Ministry of Road Transport. Now we say that as per the population of that area, that it cannot have an intersection with any other path within 300 meters. So here it is said that there's a earthen track in 150 meters, again at 220 meters.
3-meter wide earthen track is located at a distance of 150 meter from the nearest edge of the plot towards Didno on the opposite side and 220 towards Agia on the. This is violation of the new revised guidelines stated demand which will. Now that is of 2013. Now has MOT come up with any other guideline?
They are a party member. They are a party, but the guidelines which I have annexed in my affidavit.
Okay, MOT is a party.
Yes.
Ministry of, yeah. Okay, taking into account that the issue involved in the instant writ petition. Now, for the purpose of adjudication of the issue involved in the instant writ petition, the clarification from the respondent number 4 would be essential. However, none has appeared on behalf of the respondent number 1 and 4 on call. List the matter again on when?
As per your
on 15th of September. The registry shall show the name of Mr. R.K. Dev Chaudhary, the Deputy Solicitor General of India. Full stop. The petitioner is directed to serve a copy of the writ petition along with the copy of the affidavit upon Mr. R.K. Dev Chaudhary, along with the copy of the order. Writ petition, the affidavit in opposition, as well as a copy of the order.
Okay.
Thirty-five for the
Okay. None appears on behalf of the petitioner on call. It appears from records that the petitioner had not appeared earlier also. In the order dated 7/8/2023, this court had also specifically mentioned if the petitioner is not represented, the instant writ petition shall be dismissed for non-prosecution. Taking into account that the petitioner has not represented today also, it seems that the petitioner have lost interest in the litigation for which the instant petition stands dismissed for non-prosecution.
37.
May I please?
Hmm.
This is regarding steps, my lord.
Oh, you have taken steps?
Today I have taken a step.
Okay. Mr. H.A. Sarkar, the learned counsel appearing on behalf of the petitioner, has submitted that he has already taken steps today. Taking into account the above, list the matter after completion of service upon the respondent number 10.
38.
Yes. What is this IA? Hey, main petition. Yes.
I lordship for passing the interim order lordship,
What interim order?
but there is a wholesale market lordship, vegetables and food market is Gorchok.
They have a unauthorized, not to give allotment, allow any unauthorized vendors to sell their produce from the state market auction committee platform and
This matter will take some.
this matter would not take even
No,
10 minutes
I
also.
have some personal difficulty.
No, the reason why I'm saying is, are they having any market now?
Lordship, they are the allotee in the market, Lordship. Their allotment has been made as per the guideline of the Supreme Court. They are enjoying, they are doing the business in the allotted spaces, Lordship. But their allegation is that there are another Forias is there. But the Forias is in the market from the inception of the market. After that, they come. In the affidavit, I already stated they have doing the business smoothly, Lordship. There's nothing, Lordship. We constructed some temporary set for all, not for only the Forias. The allegation is really false, Lordship. Nothing, Lordship. They are doing the business smoothly right now. At the time of filing of the writ petition also, Lordship.
And what is the main writ petition?
In
Main
the
writ petition,
writ petition lordship, they has done many things illegally lordship.
No,
It is a wholesale market. They are allowing the
Not to give allotment, allot and hand over the possession of those sheds to unauthorized vegetable and fruit vendors or other unauthorized traders, and further the person may be directed to not allow any unauthorized illegal fruit and vendor or unauthorized traders to start business from the sheds, and number 4 and 5 may be directed to remove, dismantle those illegal sheds and to allow the said open to be used by the petitioner and other allottees for their passage and free movement. Let us see your allotment letter.
there are agreement. Initially, there were allotment letters, but subsequently, when the market was shifted from Mathua agriculture office to Gorchok, when the Gorchok wholesale market was constructed, the agreements were executed.
Show me one of the agreement.
Yes, I have an
Where is it?
Yes, agreement, Lord.
Where is the agreement?
Yes, sir. Lordship, page 75, annexure
Page
75, 7.
of the writ petition.
Yes, Lord. My lord, I am having some personal difficulty today.
Okay.
Just, Lordship, what happened, I am the secretary of a CBSE affiliated. So today the state government has directed all the school to host a large screen, Lordship.
Huh?
Chandrayaan telecasting. So there is
Okay.
a function from 4:30, Lordship. Even though, Lordship, I leave it to your Lord.
Hello. We'll have it on some other day. There's some interim order, no.
No interim.
No, there is no.
There's no
Okay.
interim.
List the matter. We'll have it leisurely.
Also, can you
List the
dispose it?
matter again
Fix
on.
it there and
It can be
dispose it.
taken on Friday. I am ready.
No, no, no. Not the case so
Yeah,
early.
allotment has been made as per a guideline of the Supreme Court.
List the matter on 15th of November.
Apply.
On which date? No, 16th of
Lordship.
November. On which date an attempt shall be made to dispose of the writ petition.
Lordship, I am having that matter 42. The matter has been resolved, Lordship.
Ask your junior to be there. We have already finished 38. You have to go. You say that it has been resolved.
Lordship, they have issued the vendor's license to the all the petitioners. GMC had issued.
So,
So there is just one, that thing can be recorded and disposed. I have,
take up 42. We'll take up 42.
Highly obliged.
Okay.
analogous. Our case was this, Lordship, that in Fancy Bazaar, there are some staff, fruit dealer, Lordship, they use this to sell their fruits and vegetables over the footpath law. So after coming into force, the Street Vendors Act, Central Act, Lordship, I prayed before the GMC for issuing the vending places law as per the provisions of that center. Thereafter, Lordship, the defendant respondent did not agree to that. Then we filed the writ petition. And thereafter, when the vending system was allowed by the GMC, Lordship, they have issued a vending license to all the petitioners and others also. In proof of some documents I have given, Lordship, that the stalls have been allotted to the petitioner. So item 42 can be disposed of.
No, not
Right.
the other.
Others I am not.
41. Our business, we are inside market at
Your repetition is what is the number? What is the name? No, Mr. Roy.
So my writ petition is, Lordship, 4213 of
42
4213 of
13.
item 40.
Now, what you are asking out here in the repetition is directing the research to allow the petitioner to carry on the retail sale of an MM row that is at one front side space near the entrance of Iman till they are shifted and fully accommodated to the entire open space in the L pattern. Oh, Mr. Bora, what is this? You are giving them the vending license in that said area?
Looking at a number for application of 4213.
No. 4213. This vending that order which I passed,
Lordship.
So there is a street vendors, a fancy bazaar, what is that? Traders,
Food vendors. Food,
fruit
What
vendors,
is in
they
your-
who are there in the L pattern.
L pattern
And there are some people who are inside the,
inside.
Main
Objecting to
one.
them.
and the grievance of those persons, the fruit vendor in the L pattern, is that they want something to be done by the commissioner so that they may be permitted to do some other business,
Along with food.
which those people from inside are saying that they cannot be permitted to do, taking into account if they do, then their business will be harmed. And the case of these fruit vendors thing, who are there in the L pattern, is the other people who are there in front of them are carrying on all type of business, and as such, they should be removed otherwise. Now you have given license to those people,
No, no,
isn't
no.
this
We are not on L pattern. We are on just in front of.
the L pattern?
Yeah, amendment.
That is what. You are giving this vendor's license in front of the L pattern?
Because there is an act, my lord.
Understood. That means you have to take a decision as regards the others, then give them permission to those people. Because this has a cascading effect. The moment you are allowing them to do business,
As per my information, Lord, all of them has been issued.
understood? So they have been given,
Very
allowed to do business out there. Then in front of that, are those L pattern whom you are not giving permission for carrying out any other business in view of the objection given by those people who are inside.
They have been also given. Lord.
Whom?
Vendor like L pattern.
That's the difference.
L pattern, the vendors, oh, you are there?
Yes.
You were there, Mr. Bulwa.
L-
That is
yes, yes.
your case, that was the case, no? You were there.
L patterns are the persons who are
No, no,
filed with
no.
You were the fire victim.
Yes.
Yes.
Category number 2.
Uh,
So GMC has given allotment. Now the accommodation is not given, that is one thing. But others are street hawkers. Their status is this vendors. Our status is that we are the fire victim because 88 fire incident took place. We have no license. Then we have category 2. After this Honorable High Court's order, they now take initiative to give an accommodation. That is going on. My line
No, no.
also know.
That is something
They are
that-
doing something, you are doing something against that order.
That order,
Yes,
PJ Saikya appeared. PJ Saikya Junior appeared on that particular case, my lord. That's a
Who?
part 2 matter. Lord Supreme disposed of that L pattern.
The L pattern I have disposed of.
Yes.
So that there were two matters. One was moved by another person. What was his name? Another lawyer, no?
Yes, L pattern.
Anyways,
L
whoever
pattern
he,
is-
no, Mr. P. Kotoki. Mr. P. Kotoki
Yes,
was
P. Kotoki.
appearing
Peacoty appearing for the persons who are in the
inside,
shop.
inside. He
Objecting
was
to-
appearing for the L pattern.
Means our is the space, my lord. Shop is another inside the building, and before the building, 40-foot space is there inside the railing. That is called L pattern, my lord.
That is what you are there in the L
Yeah,
pattern.
yes, space. for
But
space.
your concern is that you wanted some more business to be carried out, but in view of Justice B.K. Sharma's order, you are not being allowed.
My
and
lord, that is inside the, my lord, inside the market. My lord. That is space. 35% are not given the ground floor.
Mm.
So that is why Justice Sharma said that take expeditions as possible. Best to accommodate. That is the inside the shop, my lord.
No,
building.
I am not on that.
Confusing, my lord.
Justice B.K. Sharma's order also categorically says that those people
Who are not
who
accommodated.
are there in the L pattern means you were representing, what is that?
My lord, I representing both category 1 and category.
No, what was the name of your client?
My lord, this is Sukumar Pathak.
No. There was
This
some society or something there.
Fancy Bazaar market.
Yes, Fancy Bazaar something.
Food vendors association or something like that. man.
Yes, the Fancy Bazaar,
Market
they have made a request to the commissioner.
Yes.
That look here, you give us to vend in others, because there is already a direction passed by division by the single bench
Well, I've got it,
that
my
they cannot be allowed to vend in any other thing other than fruits.
lord. I got the name, my lord. Fancy Bazaar Fancy Bazaar group of traders.
That's
Petition
what.
number 678/2015.
He was appearing.
No, I am
He
not,
was not appearing.
I am not there.
He was not there.
I am
Who was
That
there?
was I think is confused.
Who was
It
there?
It was Senior Counsel PJ Saikya Junior was appearing. I forgot the name.
Pallab Kotoki was
Pallab
appearing for the
Kotoki-
inside,
Eh,
and from the outside, it was not PJ Sarkar Junior. Mr. P. Bordloy was
Bordloy-
initially appearing and said that it was infructuous. I said not
No.
infructuous, and then
Then it went on.
yes,
Yes.
I remember that. So there was another council who
There's
was,
another people, Pallab Kotoki appeared for one same analogous material, petition number 4767/14.
then their cases don't allow these L pattern people to do any other
Nothing.
business other than fruits.
Then Lord Tibet notified it to the commissioner to take a decision.
And I have said that if you can't take any steps
Right.
against those other people,
Outside
then
the-
in that regard, you have to consider the representation of that fruit vendor.
Not-
Now, what you have done is you have given them the license.
This is vending license as per the act.
No, understood, in front of it.
Hmm.
Then what is to be done as regard the other one? Now, if this court is going to pass an order in this thing, then what remains? What happens to that order?
Lord Tibet even directed the commissioner to look after whether these L-pattern persons will also be allowed to do other vending. Because only fruits.
No,
they cannot
I
serve.
say that you are responsible also to see the interest of those people in the L pattern, as well as also those people who are
Right.
inside. Now, if you allow the L pattern people to do the same business who are inside, the inside people will be harmed. And if you allow the other street vendors to do some business, because they were doing various other business, but because of you allowing them to doing business out there in the L pattern, you can't restrict them only to fruits
They want to sell betel nut and all these things.
and also paper plates and all. This is what,
Disposable paper.
which is being permitted to the person. Now, I say that either you take action for eviction, when you made the submission that you keep on evicting them and again they come back.
That's true. Because they on the streets and all this. But the act is such that people, there is a survey, and survey you have found that they are street vendors. You have to keep license. Ultimately, the street vendor, you have to find out a designated place. That process is on. After finding a designated place, they have to be shifted to that particular designated.
Now you have given them the license
Now-
to do it where? Fancy Bazaar.
place.
Where is the location you have given?
That designated street vending
Huh?
zone has not come up, my lord. But they are vending in this area.
Vending zones in Fancy Bazaar.
And-
What is this type of, this is given by whom? Association of Assam. What is this?
It should be from the GMC. But it cannot.
No, this type of license is what?
document is there.
These iCard, this is a license,
Yes.
provisional
License.
by GMC. Here, the area has been mentioned as where?
Area has been mentioned.
Residential address, no area has been mentioned.
No, no,
Then
there-
you have not mentioned the
there is a
vending
big-
zone. What type of this? No,
License
iCard?
as per the, I think it says as per the Street Vending Act 2014. But vending zone is not come up.
No, you have to assign somewhere somebody.
Yes.
You may ask them to sit in front of some other good shops. Ask them to sit in front of Reddish and Blue. You are not doing that. You are disturbing those other people who are doing business. Then you can't do this.
Street vending zone. This
You
act has
allow
come up.
them in all other places because you are restricting those people not to do any other business. Certificate of street vending. To do vending of fruit shop in items at Guwahati municipality and is allotted an area of 51 square meters to do business at 7 AM to 10 AM subject to. Now, name of the vending zone. So and so, registration, residential area, category, stationery, nature of vending, 7 AM to 10 PM. Photo of so and so.
7 AM to 10 PM because before the
This is
office,
certificate of street vending.
before the office during the
This has
morning.
been
you have to
issued to all the petitioners in mind.
I'm glad you.
So my petition can be disposed
No,
or
It can't be
together it may be.
no, we will keep all these things together and you file an affidavit bringing on these.
Okay.
Then I will Because then we'll have to take a call where they have to be given otherwise. You can't keep them other or allow them.
We have to bring out a retail vending zone.
If you don't do it,
No, my lord.
you can't spoil the business of those other people who have been, you have kept in the help account. List the matter well. How much time? You require how much time?
I am ready for
No,
any
you have
other.
to file the affidavit.
Huh?
You have to
No,
put
I-
this on-
No, bring those documents.
2 weeks.
List the matter on 25th of September. The petitioner in WPC number
4213 of course.
4213 is given the liberty to file the licenses so issued to the petitioner by way of an affidavit.
All these matters, my lord, on
Huh?
all this from 41 to 42.
Because that needs to be clarified, huh? Do something. 40. Because if necessary, we'll impede them.
Lord.
Because they need also to be heard. You can't do that.
Lord.
Yes, complied.
Yes, but
Okay.
in fact, the matter has become in fact.
We have been given another place for with our business.
Huh?
We have been given another place by Deputy Commissioner for run our business. That's why the matter may be closed. And the matter may be come up in
The petition is pending, Lordship, but contempt is also, there is
Yeah,
no
contempt
contempt.
may be
Lordship.
closed. Yeah.
Contempt is in fact.
Huh?
Contempt is in fact. Lordship, is not.
Contempt is in practice. The instant application, the instant contempt proceedings have been initiated, have been filed for alleging willful disobedience to the order dated 15/3/2018 passed by this court in WPC number 1645/2018. It has been submitted by the learned counsel appearing on behalf of the alleged contemners. That the order has been duly complied with.
Yes, in this case, the petitioners are the street vendor, Lordship. Subsequently, they are evicted from their, street Lordship. But during the pendency of the petition stay, Lordship, that's why they are again allowed to Lordship in this the street Lordship. So allowed to
Same-
be the
same business.
Same place Lordship.
So what was the order which was passed?
Order was passed by Lordship. Page number Lordship 24/2 Lordship.
Having regard to the until but respondents are directed not to evict. Okay.
Yes.
Has filed the instant contempt application on the ground that there has been a violation to the order dated 15/3/2018 passed in WPC number 1465/2018. It has been submitted by the learned counsels for the petitioner as well as the respondent contemners that though the petitioners were initially evicted, but later on, taking into account the order so passed by this court, the petitioners were again allowed to carry on their business. Gusto. In that view of the matter, nothing survives in the instant contempt proceedings for which the contempt case stands closed.
Apply.
45.
Lordship,
Hmm.
order dated.
Service
Well-
complete.
Yes, you have completed, no affidavit, no nothing, Your Lordship. My humble pay is that, Your Lordship, I have read one application before the annexer 6 as at page 38 before the deputy commissioner. Later, maybe run back to the trial to the deputy commissioner. Annexer 638. Issue regarding the demarcation of the settlement of land. I had filed an application before deputy commissioner under section 147B of the Assam Land and Revenue Act. And at
one order has been passed by the Honorable Court on 12/8/2020.
Taking into account that the service is complete, as could be seen from the order of the Lord Sabha Court dated 30/8/2022. Lists the matter for admission on after 2 weeks.
I'm developed.
Will dispose if it comes to me in the admission.
47.
Yes, no contempt, no.
47.
No notice has not been issued. So I think he is not interested. List the matter for motion. So, by the matter has been wrongly listed for orders. List the matter for motion on such state as may be fixed by the rate.
48.
Here we go. Take order, huh?
9.
None appears on behalf of the petitioner on call. Further to that, no affidavit has been filed and no additional affidavit has been filed as directed by this court by order dated 9/6/2023. List the matter again on 18th of September 2023. It is made clear if the petitioner is not represented or as well as the additional affidavit is not filed, this court shall dismiss the application for non-prosecution.
50.
Yes, what is this?
Last order dated my planner is supposed to file affidavit on every Karbi.
Regarding my lord, land acquisition compensation, other cases section 13. In this case, all the petitioner received the compensation except my lord petitioner number 1.
Why?
My lord, there is his uncle raised the objection against the disbursement of the compensation to him, my lord. So that case is
No, if
pending.
there is an objection, refer it to the district judge.
No, as per section 3(a)(3), my lord, that it is the competent authority is required to take the decision on that. If he fails to take the
This
decision,
is
then
under the National Highway.
Highway Act, my lord, I think
So
56.
the apportionment is also there, 3A,
My lord, 3(a)(3), my lord, 3(a)(3),
3H3.
3(a)(3), and 3(a)(3),
No, if there is a dispute
between,
and the collector cannot decide it,
my lord.
Then it has to
Like-
be,
it is
the
the
competent
competent
authority can't decide, then he has to
Yeah.
refer.
Refer it to my lord, this civil judge, my lord. My lord, in this case, my lord, in respect of petitioner number 1, there is a dispute, and it will take a decision, my lord, after hearing both the parties within 2 weeks, my lord. In other, all the petitioner received the compensation. And they have submitted the undertaking also, position also handed over, my lord. And other cases, lordship takes it on, it is under that package 3, my lord. Regarding, my lord, this is the, we have received the compensation of what is the amount they have received, all the details are here.
Mr. You, the other matter is fixed on 13/9.
13, my lord.
We fixed this on
13,
13/9.
my lord. Then
And
we'll bring it on record. of
Bring
what is
this
the
on
amount, my
also
lord.
on
My
record.
lord.
And in the meantime, try to make the reference.
Dispute, my lord, or before 13, my lord.
Fix it.
Otherwise, my lord, will.
Yes, we'll
refer it
make
to
the
civil
reference
judge,
which is there,
my
because
lord.
once there is a dispute, you can't do.
My
So
lord.
let the
Dispute
competent
between the family
authority.
members, my
Huh?
lord. Dispute between the family members.
So you make a reference
lord.
out there. You can't decide.
If you cannot
Because
decide,
any dispute, it is only when both the parties are agreeable you can do it.
yes, my lord.
But otherwise, if there is a dispute,
It is
you
got
have
to
to
be
refer.
decided to the civil court.
Okay, Mr. Jayaswati, the learned counsel appearing on behalf of the KAAC submits that all the petitioners except the petitioner number 1 have received the compensation
My lord,
and have also
subject to undertaking.
submitted the undertaking, and possession has also been taken. As regards the petitioner number 1, the said amount could not be disbursed, taking into account that the uncle of the petitioner, number 1, has raised certain objection as regards apportionment of the amount.
Compensation.
However, the competent authority is taking a call into the matter. He submits that 2 weeks' time may be granted so that the competent authority can take a decision in that regard. He also submits that an additional affidavit would be filed by the KAAC.
Kala. Competent authority for land acquisition.
Huh?
Kala. By Kala. Competent authority for land acquisition.
You are paying for KAAC?
KSU and Kala also, my lord.
Okay, KAAC shall be filed by the KAAC, bringing on record the said aspect of the matter. List the matter again on 13/9/2023.
The award for also remain pending matter.
Eh?
I have not in the award matter. Award matter.
I bring the award also.
Award
Well,
matter.
Mr.
we may be
Shall
allowed
also bring.
Produce the, my lord, award is the.
We need the individual
we'll
award.
produce it in-
Huh?
Regarding that point, whether we are required to submit an individual award or not, that is the point, lordship may decide it, my lord. As per the, my lord, we have to pass the award. National Highway Act does not say anything the individual award. 2013 Act says about the individual award, but 2013 Act is not applicable for the National Highway Act. It is applicable only for the determination of.
No, here you only pass an order.
Award, order. Yes, we have passed the order. In
Yeah,
respect of the
here
previous-
there is no award.
Yes, not award, order, my lord.
Order.
We have passed the order, my lord. In
3G,
respect-
3G, 4 only.
Yes, my lord.
order.
3G1, my lord, that is award. Award, individual award, it reflects in the 2013, my lord. That is not
The
applicable.
award is also there out there in
Land Acquisition Act
1894.
also, my lord.
But not here.
Not here is the order. And the guideline is there, how the order is required to be passed by the central government. And we have passed the order in that, by following that guideline. We'll bring it on record, the award of every village pilot, the petition. What is the amount like that?
If suppose.
And the individual award, if the petitioner requests, my lord, for filing the, before the arbitrator appeal, we'll provide them, my lord. There is no power on that one.
We have made application, my lord, for the
No,
individual
you
award.
have the individual award.
Award also, my lord.
But
it
then
is, my
bring
lord,
it on
very big,
record.
my lord.
No, only individual.
My lord, individual, my lord, it is, my lord, the first, my lord, compensation amount, solatium, and all these things are there. It is very big. It is very difficult to make the photo set. So bring it on record. I'll make a, my lord, certified copy or the original records I can produce, my lord.
You just bring it on record.
Original record.
Original
lord,
record so that we have.
So they, my lord. That will furnish them to the certified copy of that, my lord, their portion, my lord, for the, how we have calculated
The
them.
petitioner, the Mr. ACTS will also bring, produce either the
Individual
original-
calculation of the
original award, original
order.
order.
calculation.
So passed under the National Highway Act insofar as the petitioners are concerned, or a true copy of the same
My lord,
on the
yes,
next
true
day.
copy, my lord.
Lordship, I am appealing for 1 and 7.
Give me a name.
252.
I love it.
Yes. Oh. What is there? Today all Hawkers Association, this and that.
No, my lord, this is sort of a hard case because the petitioners association were allotted the mezzanine floor of the municipal market, which was already allotted to the private respondents represented by Mr. Borua. And they had already preferred a writ petition even before our allotment was made, before this honorable court. Now that is where we are in my lordship, and that is
You are
why
the
this-
petitioner. You are the SS Hawk
Yes, lordship.
Road Hawkers Association.
Association. So my lord,
You were allotted.
the mezzanine floor of the municipal market, which already stood allotted to the association represented by Mr. Borua.
Hmm.
And they had already preferred a writ petition before this honorable court.
Where?
Lordship, if lordship takes up my writ petition,
Which one?
that is 3749 of 2008
No, why the matter has come up today?
for instruction by the. So lordship, we are nowhere, we are left nowhere, my lord.
That means
Neither
that there is urgency in the matter and GMC has already taken 3 weeks time on the earlier 3 occasions. You have not filed affidavit.
My lord, what has happened is, I have checked up, my lord, what has happened is that is IA as the main case at the scene. And in the main case, we have filed the affidavit, my lord.
So,
It
okay,
was
we'll-
everything. Lordship will take the entire case as well as the writ petition number 1832 of 2018, where my friend claims that the other person is occupying that particular, they have been allotted to the Fancy Bazaar municipal market to do fish vending. In fact, it is that in that particular case, affidavit file, there is no fish vendor, my lord. That mezzanine floor is allotted to the petitioner.
You have allotted to the petitioner.
It is to the petitioner.
He is not there.
He is not there.
My lord, in 98, we have allotted as a fire victim. After that, what happened, my lord, his trading is not possible in next floor. So we file a representation.
El Petan.
Oh, no,
No, that is an. My lord, that is category 1 and category 2, my lord. Your lordship, category 2 is different category. Open space category
Okay,
2,
this is in-
when we are
inside
see-
building category 1.
Huh?
Inside building category 1. Open space category 2. So, my
lord,
lord, previously category
because-
2, I.
Mr. Bora, you next time give me a map.
My lord, this
The
is
map has to be given
My
to
lord.
understand this.
Yes.
Mr. What you call Mr. Roy's matter.
Yes.
That matter.
Yes.
That is also same location.
Same location.
no. That is not the same location. SS road. This SS road is from Goenka Readymade to the MG road. That area he was vending. Then PIL came. PIL for the compliance of the non-compliance of the PIL order, contempt was positive. Then ultimately that area has been declared as a non-vending zone. At the same time, all these persons are given a mezzanine floor of the Guwahati Municipal Court market. And
Same.
they-
Yes.
And
You-
they were not shifting now. They want that order has been challenged in this petition.
Because lordship already.
No, you were earlier vending out there from Goenka Readymades to
To
MG
MG road,
road.
that main road.
Then lordship pursuant to the honorable division bench.
Goenka Readymades to that small road. That road which is,
LIC
you
building
can't
road, my
take
lord,
the
that is
car.
overcrowded road, my lord. that-
You can't take a Bijuli Cinema.
Yes,
Yes,
usually
that is the-
and
yes,
That road.
Rupasri Cinema Hall.
So that is the road.
That is the road we were there. Then the
Now it is
division.
no vending.
Now, this has been declared no vending because of the PIL order as well as subsequently because contempt. We have been declared a no vending. This is now a parking area. Now,
Yes.
illegally,
Yes.
everything can be done. my
Okay,
lord.
now thereafter, you have given them to the mezzanine.
Mezzanine floor of the
Yes.
particular building of the GMC market. To
Now they are doing business there.
No, lordship,
They are
because
challenging
they
that-
had already filed a writ petition.
And they have got an order.
No, they have filed a writ petition that because this is already allotted to them. In fact, the prayer is a writ of
Oh.
certiorari shall not be issued to set aside the decision, if any, to settle the outsiders, including the hawkers of SS Road in the mezzanine floor of Fancy Bazaar GMC market. That writ petition was prior to the allotment made to the petitioners.
So was any allotment made to them?
As on date, they were not, they are not not a single fish vendor is there. They had been shifted down below, 1 or 2 may survive, Manoj. That mezzanine floor is empty. they are shifted there, then they are
You
challenging.
want the mezzanine floor.
Lordship, we are challenging shifting to the mezzanine floor, my lord, because
You don't want the mezzanine floor.
mezzanine floor, Lordship, as such, the height is less than the normal floors. Then it is not a space which can accommodate 250 vendors, my lord. That is also one of the challenges. Our problem is, it's not, we are not against shifting.
You have been given a street vending license.
We were there, Lordship, we were recognized.
Yeah, have you been given a street vending license?
As of now, Lordship, no street vending license, but they had carried out.
But I've done that instruction, I don't have it, but this mezzanine floor has been declared as a vending zone for exclusive for assessment. Exclusively for this person will only move on to.
But they say that they won't fit it.
My lord,
They say that they don't fit in because this
40
order has been passed because of the PIL, because of contempt, and we have to make an arrangement.
What
for
business
special
were you
arrangement for-
doing earlier?
Lordship, vending clothes,
What?
ready-made clothes.
Clothes.
Yes, Lordship.
Basically close.
250 vendors, my lord, and we also employed some.
250 vendors,
Yes,
clothes.
Lordship. Yes, and my lord, some also had employees. All total, my lord, at least 2,500 to 3,000 persons have been affected by their decision. And in fact, it's a sad thing that some of them had to come over and say that to meet their school fees of their children, they now have to sell off their jewelries or give them on loan. This is the situation because since the day of 15, my lord, they have not been able to properly even take care of their livelihood. That is why, my lord, is high. And I'm
So what
living
do you, where do you want to vend now? Tell me.
Lordship, our writ petition is give us a proper place because if Lordship looks at the 2014,
Proper place means
actually, my lord, if they intend to shift 250 vendors to a small place where, I mean, there's hardly any space, an adult cannot
okay,
even
where do you
stand.
want to go?
Lordship,
Give us a location.
no, my lord,
No, you have
if
to give,
Lordship,
where will they accommodate you? Tell me where
if
you want to
Lordship
go.
gives me some time, maybe I can, maybe
You can want to go to Kunapur.
I can
So there
obtain
is some place.
instruction. But,
Some place has to be there, na?
but Lordship,
You tell me where. Because they have to also do. Now this place has been made a no vending. Very well, that's the policy decision they've taken for the purpose of using it for parking or decongestion and all these things. That policy decision you are challenging here.
yes, Lordship.
Okay, so they have done it. Now, the thing is, where can they in the alternate accommodate you? Near that market, which is now improving, na? That Gorsuk area. Gorsuk area is improving.
Gorsuk area is improving.
As of now, there are two places which is improving. One is Gorsuk and the other is the VIP road.
Yes, yes.
That the tennis,
Tennis is that
the
particular.
tennis where you had the Ginger Hotel and
Yes,
all.
yes.
These are the two areas now which is only developing. Other areas you don't see anything new.
Not a single piece of land is there. Let them give a proposal where there is land they want to go.
Lordship, to begin with, how could they allot us there when they knew fully well that that place was allotted? That is one of our challenges.
No,
that
there is no
Lordship
other
would-
way. No, Mr. Sharma, you have to be reasonable.
No, that
Because
was,
can this court just set aside their policy decision to make this a non-bending zone?
no, Lordship,
If that cannot be done, the next is the question is they have said that they have been giving you the mezzanine. You say that the area which has been allotted is not sufficient.
Lordship,
Very well. So you have to vend somewhere. Where? Tell me where. Give us some area, or they will. If we ask them, they will send you to some other place. Pamuhi. He wants that. Greater Guwahati, Polasbari.
Then
This is what they were going to do. So think about what is there, what can be conducive. Have a word with your people where they can carry out their business also something. But has to be a reasonable solution. It
Lordship,
can't be an unreasonable solution.
in fact, Lordship, the 2014 Act, it says, yes, the vendors have to be shifted from busy places, but it is specifically mentioned that the places to which they may be shifted,
they have to ensure, authorities have to ensure that these are proper vending places, places where they can carry out their livelihood. These are specifically laid down in the Act of 2014. But in any case, my lord,
No,
leaving
no,
it aside,
they can carry out the business nowadays. Wherever you stand becomes the vending zone. People will go.
All the
Isn't it?
footpath are occupied, my lord.
That day somebody was telling me that one of the malls out there is not working properly. Somebody said that no, why don't we have a McDonald's out there? The moment you have the McDonald's out there, people will start coming.
Now in the evening, you cannot move the GS road, my lord, because of that 2-3 mall. The congestion is there.
The absolute congestion, chaos, because of the vending, not because
Not
of
vending,
the,
but because of this.
but the shops which are there. So you have to come up because you are a big number of 250
yes,
members.
lordship.
So people will definitely, if 20 was known out there, people at that point of time used to go and shop out there at that estate. Now the people has to shift from there to some other place. People will definitely go.
If a fire takes place in Fancy Bazaar, you can know even fire tender cannot move. Ambulance cannot move.
Now, because of their parking, they have made it a parking zone. Now, lordship, imagine if a fire takes place, all the vehicles, how will do they intend to shift the parked vehicles? Vehicles will burn, vehicles will explode. This is the policies they come up with. How can you justify?
No, entire road is not a parking
People
area.
can shift. If there are vendors
Yeah,
in an
either-
emergency, they can shift.
But Mr. Sharma, you have to take a
Yes, lordship,
as to
let
what to
me
do.
also.
Now,
obtain
if we are
instruction
getting
because-
a mezzanine floor, whoever can be accommodated, get it accommodated. And then thereafter, you take up for the other people. Come up with a solution.
Lordship,
That is the
Lordship.
only way out.
yes, my lord.
And Mr. Burba, what cases is yours? You have not been allotted.
My lord, allotment is given in mezzanine floor, my lord.
To them.
Then, my lord, they have taken decision that Minucho Mayor in Council that this fish vendor should be shifted to ground floor by destroying the toilets or something else. But that my lord, decision is not acted upon. That is why repeat is not pending. So we are now hanging, my lord. And
You are
in
who?
the-
What's your name?
My lord,
Not your name, your client.
client's name, my lord, this is Fancy Bazaar Market Dealer Secretary.
Market
Lordship,
level.
There are
fancy-
many
You are there in the Elbeton.
El
No.
Petan, yes, because this is the parent association, some
And what is that one which I disposed of? Fancy Bazaar?
Fancy Bazaar group of traders. There are many associations of them. All
but really one of their
Well,
fire victims.
well, two-
That's I'm repeating.
in order to item.
Where is your reputation?
Well, my reputation, they annex, they made us party. My
That's why, my
reputation
lord-
is not
Now,
annexed.
are you a party?
Yes, made me party.
Then
That's
is
my-
your reputation alive?
Yes,
yes.
that is a different.
Okay.
It's not
It has to be, madam, that
This
has to be checked.
reputation along with WBC number
183.
1833 of 2018.
2018 on 20. We go for a disposal.
Lordship,
Lordship,
because
20
that mezzanine floor is empty. They are not there in there.
On 19th of September.
Lord.
19th September.
Lord.
On which date an attempt shall be made to dispose of all the.
in the meantime, lordship, I crave liberty if my learned friend agrees and if they take out some place for vending, maybe we can approach them also with some better representation.
On the next day, the learned council appearing on behalf of the party shall also explore as to whether any appropriate vending area, as to whether there is any appropriate area where the petitioner can be allocated, allotted, taking into account that as per the submission of Mr. A. Sharma, the learned counsel for the petitioner, the area in the mezzanine floor of the Fancy Bazaar market, DMC market, is not sufficient to accommodate all the vendors of SS of the petitioner.
Apply, sir.
53
Maybe the,
Hmm.
that petitioners are big Khotian holders, my lord. They pray to the NDC to give them that patta, my lord. So now the main writ petition is pending. It is 2011 matter, my lord. It has actually just to come up for hearing. It is order also there, and it is not disposed of. That now the Khotian
Petition has been filed by whom?
that actually there was a village, that Radhakusti village, that was sanctioned for default of payment of revenue. And proprietor, they have approached the owner. And
Okay, well, this is the 2011 matter.
yes,
To take up for disposal.
so
So, আমার তাহলে আহিব নহয় এইটো। Okay, taking into account that the petition is of the year 2011 and the pleadings are complete.
yes,
It's the matter for in the column of what is that? The column to be? Oh no, no. Old pending matter. Not Kali Liston. Huh? In the column of old pending more than 10 years on seventh of September.
Lordship,
I will be considered.
Not necessarily, it will be finally disposed.
Lordship, a date after that, kindly, Lordship. A date after 7th of September.
Why?
My senior would not be here, Lordship.
Who is your senior?
Take him. Take him.
Well,
Much okay.
64.
May I appeal? But this is for subscription of legal error original petitioner.
Who died?
Petition number 3.
Eh?
3. Petition number 3. Sukhdev Talukdar. The applicant
You're
says
there. Now for you. The instant application has been filed seeking substitution of the petitioner number 3 who expired on when?
Lordship 29/6/2019.
29/6/2019, leaving behind his son.
Lordship, actually the applicant is the daughter-in-law of original.
Huh?
Daughter-in-law of original matter. Lordship will find that paragraph.
Leaving behind?
Leaving behind his son Navajit Talukdar. But before he could substitute.
He died.
Died.
Leaving behind seeking substitution of the petitioner number 3 who expired on 29/6/2019,
Leaving behind
Navajit
Tat.
his son,
Navajit Tat.
as well as his daughter-in-law and 2 minor children. It is also mentioned that pursuant to the death of the petitioner number 3, the son of the petitioner number 3, Sri Navajit Talukdar, had also expired on 16/2/2020. Under such circumstances, the applicant is the legal representative who has survived, who represents the estate of the petitioner number 3. In that view of the matter, the instant this court is of the opinion that as the cause of action. This was for what matter?
Lordship, this is for compensation for land acquisition.
As the cause of action for which the writ petition was filed by the petitioners, including the respondent petitioner number 3, survives upon the death of the petitioner number 3. The applicant, Srimati Sangeeta Talukdar, wife of late Navajyoti Talukdar, resident of Borpeta Road, Ward number 10, in the district of Borpeta, Assam, 781301, is substituted against the name of the petitioner number 3. The registry shall make necessary correction of the records on the basis of the instant order and also shall update the same in the CIS. With the above, the instant petition in I stands disposed. This petition is still pending. Goodness, these are 2014 matters, and I don't understand why these 2014 matters are not before this court. We are getting 2020-21. Yes, tell me, Mr. Borbuzai. Huh? Where settlement lands, land compensation, these matters are not coming. This is the matter on writ petition like everybody. This is the matter again on 30/8/2023.
Lordship, my information, other information also died. That regard, they have my same petition.
Not necessary. One is alive. No, I have made it. If this matter comes up before this goes, I'll take care of it. I'll pass the order that if you are not entitled, you are entitled or not entitled, either the petitioner or the legal representative do it. What is there all these things? Don't make this complicated.